after 3 weeks. Like, I try to make protective one people.
Led to what?
The we have challenged the order of the research.
Okay.
And at a similar practice of a criminal petition for motion matter on Thursday matter. It is against advocate Mallet for giving in the legal scrutiny report matter. And there is a charge as well as against Potter matter. Thursday, what's allowed for motion. DPO. So I think with the last second. Right. Can that make it taken up at 4 minutes? Might take only 15 minutes.
Provided it reaches
70. Okay. That is our that time.
or you have to wait for your
The conviction is for 3 years. 3 years, 5 months.
you are paying for suspension.
No much. Final
The final hearing then subject it to condition that we complete the bail matter. If bail matters are over, then
after the payment. Highly up. Item number 2. My lord, allegation is under section 379, my lord, already 35 days, my lord. And the alleged stolen articles, my lord, were recovered on the day of arrest itself. Now the accused is languishing behind the bar. Further detention will not help, right?
what is the article which has
That is, my lord, kindly come to Caesar list, my lord. I have typed copy, my lord, page 8, my lord. Remote radio unit, my lord. We are, my lord, we deal in second-hand goods, my lord. All these we collect, my lord, from various places. When these are not in working conditions, these are changed.
correct.
My lord, item 2 and item 3, both same, my lord, from the same peer. My lord, 2 is the person from whose custody it is recovered. And in item number 3, that person who stolen the article and delivered to the person. So, these are stolen articles from my lord, various towers, my lord. Battery and remote radio unit, my lord. This FIR, this remote radio unit is cost about 1 lakh, my lord.
CD
will be recorded, my lord. There is a group, my lord. One cannot do all these things, my lord. Some have to, my lord, stolen and some has to, my lord. So, my lord.
heard, Mr.
My lord.
No, without verification.
My lord, only 2% has been arrested. Only 2%. Yes. And my lord, these kindly see, laptops has been recovered, 6 laptops, my lord. Battery, my lord, all these, my lord, these are second hand, my lord. And my lord, police has already completed investigation. 35 days already behind the bar.
Let us see the case.
It said to be 60 days, my lord. Vacation is there, my
No.
they will cooperate in the investigation, my lord. They will not keep the jurisdiction, my lord.
Without perusing the case, that heard Mr. F. Khan, Learned Petitioner, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashat, considering the nature of allegation, they will inquire against. They will inquire perusal of the case very good. Hence call for the case.
Immediately on reopening, my lord. My lord,
Not before vacation.
Hearing
Immediately on reopening.
3 or 4, my lord.
Third.
3rd January. Third.
Same order for item number 3.
3 also. My lord. Oblige, my lord. Item 4. In this case, lordship, the petitioner has been shown arrested, lordship. The main case is before your lordship, I can. So in this case,
He was inside the jail for about 1 year, 3 months, Lordship. And the FIR name accused who has been charged, Lordship, they all got bail, Lordship. That is, I have an example. FIR name accused, Lordship, to FIR registered. He was initially arrested in connection of Morigaon PS case number, Lordship, 156. Then, Lordship, the FIR against the petitioner is at page 27, Lord.
Now, what is the stage? Is
The Lordship,
charged
it is
case.
starts frame. The Lordship thereafter, the one witness is examined after framing. Lordship. Lordship will find the other co-accused bail petition. Lordship starts from court below also release the accused other defendant accused person. Lordship. Lordship will find it is at page number 75. Lordship. This petitioner was arrested, Lordship, in connection with item number 70, Lordship. Lordship fixed yesterday for tomorrow, Lordship. In that case, Lordship, charge frame under section 13, Lordship.
Which petitioner, the present or Jubair Khan?
No, this regarding this petition,
Mustafa.
Mustafa, Lordship. Then after before framing of charge, hearing was done, Lordship. As per that, Lordship, charge was framed under section 13 of UAP Act, which is not come under the chapter 4 and 6, Lordship. Where in chapter 4 and 6, Lordship,
Against Mustafa charges were framed under section.
that case, Lordship, 13, item 17. In this case, for the all accused, Lordship, 18, 19, and 20, Lordship.
It comes under those chapters.
Lordship. But Lordship, they, after that, Lordship, after going through all the things, Lordship, this person got bail. All the charged accused, Lordship,
No, no.
except
My query is, if it comes under chapter 4 and chapter 6 of the unlawful act, then 43D5 will come.
yes, Lordship.
Then if 43D5 comes, then whether this court can grant.
Yes, Lordship. Because that discussion has been made, Lordship, in the order sheet, Lordship, passed by this coordinate bench for FNM accused at page number 100, Lord. That Lordship will find it is start from para number 4, then Lordship, it is in para number 7, Lord. 7, 8. Because of this Supreme Court held in K. Nazib and lot of other cases, that is K. Nazib and
NI versus Jawhar
yes,
Ahmed.
that is, of course, the law has been decided in that.
Jawhar Ahmed.
No. It's Harvard. Tawaf Asal, Lord. In that case, and against this person, Lord, all the person got bail, Lord, by the court below it. In that case, the section 43 has not been explained, but in High Court order, Lordship, in coordinate bench, Lordship, this has been discussed regarding the 43, Lord. And
Where it is?
it is in Lordship, we will find it page number 103, Lordship, para 7 and 8.
What was held by the coordinate bench?
Lordship,
What coordinate bench held?
this is Lordship, Justice.
No, what was observed by the coordinate?
Ultimately, the Lordship, after discussion, the bail has been granted,
No,
Lordship.
what was held that 43D5 was not applicable?
43D at para number 8, the learned court below had framed the charge under charge against the accused persons under section 18, 19, 20 of UAP Act, and that the bar of section 43 D5 of UAP Act is applicable yet. It has been well settled in the case K. Nazib. It is held that section 43 D5 of UAP Act merely provides another possible ground for competent court to refuse bail. In addition to the well settled consideration like gravity of offense, possibility of tampering with evidence, influencing the witnesses, and chance of accused evading the trial by absconding, etc. And in case of Johur Ahmed Shah Watali, it has been held that degree of difference between the satisfaction to be recorded by the court is different and lighter from other special statutes like the MOTA and the PS Act. Having considered above and also having adjusted the submissions of learned advocates of both sides and having gone through the material collected in the charge sheet and further and having reckoned the materials from the position of the accused person and the materials available in the case diary as a whole, and further balancing the period of detention with that of measure of gravity offense, this court is of the view that prima facie case for granting bail of the accused person made up. In our case, Lordship, in the charge sheet, Lordship will find a allegation against the accused person. Lordship is that Lordship will find against allegation at the page number 71, Lord. Page number 71, para number 15, Lord. May I read, Lordship? May I read, Lordship?
Yes.
He, Mustafa, he voluntarily joined the modules of Ansarullah Bangla team and made the core members of ABT, namely Mehbubur Rahman, Abdul Talah, and Aminul Islam. He received a huge amount of funds from Mehbubur Rahman through SBI account number of Mamnur Rasid for using this amount in jihadi activities. Mustafa could not give satisfactory answer why the amount was deposited at his account. He assisted in organizing a week-long jihadi training program at Morigaon, where Mehbubur Rahman, Aminul Islam, Abul Kalam Azad, Kajibur Hussain were attended. The training included physical exercises, lectures on atrocities by Hindus on Muslims, display of videos of Allah's atrocity on Muslims, display of videos of wars being fought by Mujahideen in Afghanistan and other parts of the world, and reading of certain books like Tawhid, Kalima, Iman Ki, etc., which pitch terror-related activities for establishment of Islamic rule. He knew that Mehbubur Rahman, Aminul Islam, and Abdul Talah were Bangladeshian propagating jihadi activities in Assam. This is the allegation, Lordship.
Whether materials are before us.
No, my lord. That I was like to point out, my lord. Fact is that, my lord, that case was allowed on perusal of the LCR, my lord.
LCR with
My lord,
that
my lord,
matter,
may,
Lordship.
yes, my lord may call for the LCR, or my lord may call for the record of the
Oh.
PA, my lord, 2916. The LCR photocopy of the LCR is available because it is disposed of on, my lord, only on, my lord, 8th of
Yes.
December, my lord.
2916, that is
Latest one is 2916. The record is there.
2916.
That matter,
So,
Lordship.
my lord, we have to examine that
2916 is
29 last page, Lordship. 100 page, 100.
because disposed of
Next to the one,
Disposed of.
Eh,
The record is with that bail application.
LCR photocopy of the LCR is with that, my lord, case. So, on perusal of the test record, my lord, can be. Otherwise, my lord,
And Lordship, my only submission before your Lordship here, 15 numbers of persons are seated in the search. And out of 15, Lordship, all the person got bail except Mustafa. It is, I have annexed this order sheet that has been, the trial court has been granted bail to this person. It's
why
not,
Mustafa's bail was not allowed.
one of the.
I think Lordship, the Mustafa
Let us
did not
go.
file any bail application before the trial court, because Lordship, he has brought to Morigaon court before framing of charge. And that was the initial case where allegation was that Lordship, he has collected some fund in his account. And in that case, Lordship, charge frame under, in item number 70, Lordship, charge frame under section 13, Lordship.
Okay, let us call for the case record of bail
Can it be, Lordship, on 21, Lordship, possible? Because the record is there.
There it is, the record is on view page.
21, can have at 2 o'clock.
Let us heard Miss S.K. Nargis. Also heard Mr. Bharat. This application for 9 Mustafa Yasif Mustafa, who was known to be arrested on 7/9/2020 connection with Corbetta PS case number 763. No, in connection with which case?
In connection to Barpeta PS,
Corbetta
Lordship.
PS case
This session case number 10.
763/2022, on the basis of which session case number 10/2020 was registered and pending court of submitted. Charges were framed, charge sheet was laid against the present petitioner along with 14 other
Yes, sir.
accused persons, and all the 14 accused persons were already charged on bail. And the last accused person to be charged on bail were was Habibur Rahman and Ivan Hamidul Islam, were released on bail by this court, by a coordinate bench of this court by order dated 18/12/2023, 8/12/2023, in bail application number 2916/. It is submitted by the counsel that for considering the state bail application, it can copy of the case record of Corbetta case record of the taken case as well as concerned police case diary of the concerned PS case was called for, and same is lying with the state case. Hence, same may be called. That is enough of the result of the can copy case for consideration. As the can copy of the case record is lying with bail application number 2916/2023. There is the direct case record of bail application number 2916/2023, along with the can copy of the record which were called for in that case before this court on 21 where record.
Obliged.
Gateway Property Act of it is not Guwahati itself, but it but it is not okay. Because he voluntarily acted because the picture is missing.
Will it be possible?
Lordship, it's 18 day today, so let it come up on 4th of January,
4th
Lordship.
But it was on the last day, because his account was also admitted in
In fact, my copy is incomplete, Lordship. Page 2 and 15 is not in my copy. Neither the cost title, neither the
I
prayer.
will try it today itself. Today itself. Kindly, madam. Otherwise, I will not have paid my.
Okay, if it does not come,
Yeah.
we will pick another day.
Yes, not.
Mr. The
Eight of
age of the council for the also heard we shall that it standing. You are
I'm appearing for railway.
that it council for exponent that council for the that is adapted. All for the case that all for the case that it council for the that produce the case on the on 22nd September. Let this case be recorded.
Much okay.
Third Miss S. H. Chaudhary, who submits that the amendment that the petitioner has filed the amendment not brought on record and prays for fixing this matter after prayer.
Four 30th application matter. The absolutely commercial dispute between the two parties matter. Page 15 is the FIR matter. It appears from the FIR matter itself. There's a relationship and transaction going on to 2015 minor. And I have also given the some post-dated check for that. And he is incurring some interest over it. And now, as I have failed to pay the interest and the principal amount, now, here, 5 years. Absolutely, there is no case of foot pain. And admittedly, he has received the part admittedly in the FIR. Regarding post-dated check also, he has that. That security he is having.
Now, what is the allegation that you took money from
Him
the
On the-
informant?
for the investment. I used to pay him in the interest from 2015. I have given some checks also post-dated as security. Part payment also I have made. Now I have paid the full payment.
You have paid the full payment or you
No,
failed to you
I
failed,
have, as I failed now,
therefore he has
there's where is the case of foot pain? From 2015, admittedly, he said we are in the good relationship and take money from me, paid me in 2015 also I
yes,
have paid.
Mr. Paraj.
Other remedy available regarding this type of case. Definitely. Though the amount is very high, 1 crore 35 lakh.
But the post-dated check also I have given.
Third, Mr. K. K. Thoda, submitted
That is the sitting with the call for. Otherwise,
P8 of this application that the court the case of the court of has been filed by petitioner Parimal Chitra, who is apprehending his arrest connection with the two TS case number 219 slash 2023. The list of accusation in this case that on which date FIR was filed?
Let's sit on George John. 21,
On 21/11/2023, one Sripad Roy had lodged an FIR before the officer in charge of the inter alia, stating that the informant was having good relationship with the present petitioner who used to take money and thereafter there was a regular monetary transaction between both of them. However, in the year 2015, the petitioner asks the informant to invest in his business and the informant accordingly paid money to him with an arrangement that
With some amount of profit.
he will return back the said money with some amount of profit. And it is also stated in the FIR that the petitioner had returned back some, returned back the money partly to him and issued some checks, post-dated checks, and assured to return back the entire amount. However, he has failed to do so, and an amount of rupees 1 crore 35 lakh is stated to be outstanding against the present. Learned senior counsel for the present. Learned senior counsel for the petitioner has submitted that admittedly from the perusal of the FIR, it appears that there was business transaction between both the informant as well as the present, and the present petitioner also repaid back money, repaid back part of the money which he took from the informant. And if and on his failure to repay back the whole amount, this FIR has been lodged only to harass the present. It is submitted by the senior counsel that dispute, if any, between the petitioner and the informant may be of, if any, between petitioner and the first informant is of civil nature, and it and the FIR has been lodged against him only to harass. It is further submitted that the petitioner is ready to cooperate with the petition, and therefore he plays for the card. On the other hand, learned additional public prosecutor submits that perusal of the case diary will be necessary. Hence call for case
24th of January.
24th January. However, in the meanwhile, considering that apparently it appears that the dispute between the informant and present appellant appears to be of civil nature, the petitioner thereby directed the court investigating officer of dispute PSC 219/2023 within a period of 10 days from the date of this order and cooperate. If he does so within the stipulated period of time, in the event of his arrest, he shall be allowed to go on free bail of 30,000 subject to the satisfaction of arresting authority, with a condition that he shall cooperate in that is 20, which date
24th of January.
24th January.
Public.
May please the first and the 438 methods and the offense is 120B 4 page 40648. Hello, I would like to take a lordship to page 10. This is a complaint filed by my client matter and the practicing lawyer in the law court matter. And in the FIR, I was not named in no way, because this is the FIR regarding the
Where is the FIR?
page 10, your lord. This is the FIR is relating to the transaction of the my lord land about some by giving a false affidavit, my lord, they have cleaned up some money from this plaintiff. I'm a petitioner. My lord, what I am to say, my lord, that your lordship will come to the page 13, my lord. That is the general power of attorney. Page 13, 14, my lord. These people were identified one chief Forest Kolita advocate. My only thing is, my lord, that the sale agreement, your lordship will find in page 19 and accept 3, my lord. This sale agreement was done by the notarized, my lord. I have identified them as my statutory duty, my lord, when they have gone for this agreement, deed for agreement sale. So that is the only thing that either I was not named in the FIR, not anywhere, my lord. On the basis of this, the police, without serving the 41A notice, just coming to my home, say you come to the police station. That is
In
the
the
apprehension.
FIR, what is the allegation?
Allegation, my lord, these accused people, by forgery their signature, my lord, the landlord, they have adduced him from the money matter, 64 lakh something. That is in the FIR. The accused are, one is Debojyoti Nath, Imtiaz Ahmed, Patsupotim Toikia.
What is allegation is of forging the sale agreement.
No. The allegation is that by producing the power of attorney, they have induced petitioner. I mean, plaintiff, my lord, informant, by selling by giving the power of attorney, not by the sale deed, Your lordship will go through
And
the.
you have only identified the.
Yes, my lord. I only identified in the sale agreement, my lord. Deed of sale agreement. That is also not sale deed also. By the notary. That is the issue.
Yes, Mr. Parakh.
Yes, मतलब power of attorney was मतलब registered. It was
That was by
at the time
other.
Forest Kolita. Yes, मतलब. He is.
I am only, my lord,
Sale agreement.
identified the sale agreement.
You are a practicing lawyer.
Yes, my lord.
But मतलब regarding that money, मतलब money may be given after the agreement, sale agreement, and without knowing the person, identifying the same, मतलब without
My lord,
verifying
they
their identity card or.
My lord, to know, my lord, when they go for this
Yes.
signature, they have to produce their identity card. They have produced it, my lord. How do I know, my lord, he is a
You
fraud?
cooperate it.
Yes. I am cooperating, my lord.
Heard Mr. K. Bhattacharya is learned of the court. Whether Mr.
This is
Parasha
notarized.
is there be required
मतलब it is written.
for God, Mr. K. Parasha. This application for filed by the petitioner, Om Krishna Srestha, who is apprehending the arrest. This could be a case number 2291 2023 420 41 123 of the FF. The list of accusation indicates that one Porik Bolita had lodged an FIR before the Commissioner of Police, Kamrup Metro, on 11 Kamrup Metro, which was forwarded to the officer in charge of Dispur Police Station for registering a case, wherein 4 accused persons were specifically named and inter alia was alleged that the informant was cheated by showing some false document him and he how much money he paid
According to the FIR, my lord, some
85 lakh,
55 lakhs.
55?
Yes.
Or 85?
Yes, yes, yes. Total 85.
And the informant had paid this 85 lakh to one of the accused persons named in the FIR. Then it counted for submitted that the present petitioner, the practicing lawyer, the district courts at Guwahati, and he has not been named in the FIR. It is further submitted that he had only identified a deed of sale agreement which was executed between one Devajit Nath and
Joint the
the informant for apart from identifying the execution, executor of the sale deed of agreement, he had no role in the offense pledged in the FIR. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate and therefore he prays for a lawyer. On the other hand, learned petitioner public prosecutor submits that considering the nature of allegation, FIR, perusal of the case that hence call for
24th of January.
24 January. However, in the meanwhile, considering submissions made by the petitioner, namely Home Krishna, hereby directed to appear for investigating officer of Deputy 229/2020 within a period of 10 days from date of cooperation. If he does so within stipulated period of time, in the event of arrest connection with it would be a case that he shall be allowed to go on interim bail of 30,000 subject to satisfaction testing with condition that cooperate that is state with
24th of January.
24th
stabilizer.
Wait. Twenty-six, LCR, up to that LCR was called from a lot, but
My lord,
LCR not received
In
much.
this case, my lord, this is the second time it happened. This petition is pending since long. My lord. My lord, may I read, page number 29.
No,
LCR not
Earlier,
before
earlier,
that.
my lord, 4 PW is examined, LCR is there. The last item is that.
Oh,
LCR is there.
as per cause list, not since so. we have
LCR
not
is there.
checked up.
It-
LCR to asani. LCR.
LCR is there.
So,
My lord, at this stage, my lord, earlier High Court order, that before framing charge, I approved. Court directed me, do you come after framing of? Now, my lord, I have approved my 45 PW.
Charges were framed
Charges framed, 5
under
PW.
22(3).
When it is fixed. At 5 PW is examined. What is there in the record? And my lord, kindly say,
Now,
that-
on what ground you are praying for?
I am praying for my lord as the earlier High Court order, I was directed to come after framing.
No, you have come.
Yeah.
That is okay, that you are before. Now, what is your ground for bail? Because section 37 embargo is there. How will you jump? What is your ground?
My lord, in this case, my lord, I go to the merit. Initially, that can presume that I am enough. I am the employee of the transport company. That is recorded.
Merit, we cannot go into it. Now, because charges are framed, evidence is going on.
At-
It is for the trial court to see.
3,200 bottles of cough syrup. Used.
My lord, at this case, I am the employee of the transport corporation.
You have not challenged the charges. Charges are framed against you. That means prima facie materials are against you. If prima facie materials are against you, 37 comes into play. Now, if 37 comes into play, you may not be granted.
My lord, I consider my detention period. Here I am,
What is your detention period?
my lord, I have been arrested on 6/7/20.
How long you are behind the bar?
1 year, 5 months, 12 days.
You have to wait for some more.
My lord,
You
consider-
show me any authority. Because detention period, because of the
No.
apex court's observation.
Yes.
That prolonged incarceration will override the embargo of 37 in certain cases, certain circumstances. So you have to show me that for 1 year, 5 month period, an accused
Sir,
will
my lord, there is judgment is there 1 year, 6 months. There is judgment, Nitish Adhikari. 1 year,
wait
6
for 1 year, 6 months. Wait for that period. Then you come. One year, 6 months, and 1 year, 5 months. are-
Otherwise, there what I thought consider the elder state my lord. Earlier I have approached. So your lordship may consider on the
Total
in the
10
light of my earlier order.
total 10 witness as per the search sheet. I have already examined it. So you may
Your lordship may grant bail on the in the light of the earlier High Court. 829.
No, High Court has not asked you
at this
to,
stage maybe
that
for
bail
speedy
would
trial.
be granted.
I put that at that stage, my lord, charges was not paid at that stage, my lord.
Yeah.
Now, my lord,
It
the-
has not said that after framing of charges, bail will be allowed. After framing of charges, bail will be considered, but you have to show that you have a case. You are on prolonged incarceration ground. Now, you are not able to show that for 1 year, 5 month period, bail can. We may fix it in after vacation. And
What?
updated
Yes, sir. Till
updated case record would be called for.
my lord, 8th of January.
No fixing. Heard. Heard, Mr. How much, what is the period of detention now, till
Now,
now?
my lord, 1 year, 5 months, 12 days.
Heard, Mr. A.H.
H.R.
H.R. Chaudhary, Senate Counsel for authored Mr. K. Gilbarajan, petition who submits that the scan copy,
yes,
scan copy.
Yes.
It is updated up to
my lord. It we received on my lord 21st of November. 21st of November, order is taken the last order. Last order up to my lord 3rd of November. Copy received on 21st of
next date is on
it was fixed on 29th of 11. It is already gone, my lord. Thereafter, it is not updated.
that
It on 21st.
and additional copy prosecutor submit that scan copy which was called for is updated only up to date
3rd of November.
3rd of November. Let a report be called for from the learned trial court as to as on date how many witnesses have already been examined and what is the status of the trial. pending against the
मतलब remaining witnesses after 311 maybe मतलब otherwise
remain
remaining witness
remaining
after
witness. How many witnesses were examined
after
after
4 that is there मतलब
after 3rd
November.
of November 2006? And what is the status of trial pending against? Let this case be discussed again after 23rd. Let this
20
case
23rd to বন্ধ আছে
I take till that, but it may be on 17, 17.
বন্ধ আছে
let it be on 23rd. We will consider on that day you may.
But the tip of that day,
We are considering every day, but we cannot say that bail will be granted.
notice to issue respondent number 2, my lord, but there is no office note with regard to service of notice. My lord. I come along with the office note in the first week of January. My
You have taken steps.
steps have been taken as per office note, my lord. Steps were received on 3/10/23, my lord. But there is no report.
Heard Mr.
So RS Mr. on behalf of MSK Dev.
R.S. submitting on behalf of the state that council for also heard the case. Appears from the office from 6/7 that though the scanned copy of SCR has been received, however, it also appears, however, there is no office note regarding the question as to whether the notice issued to respondent number 2 has been served. It was issued through registered post with it. FOXO is there,
My lord, section 4.
then it has to go according to
मतलब
the Deepak Naik. Through
दीपक नायक sir.
you take fresh step.
But-
What was that? Regarding service of it also appears that the steps were taken for issuance of service, issuance of notice of respondent number 2 by a registered post with it and not in person with guidelines issued by this court. The case of Deepak Naik for state of Assam. Let the petitioner take fresh steps as per the mode prescribed in the case of Deepak Naik for state of Assam. So, again, before let this case be decided again after. Okay. Within
Uh, in the meantime मतलब up to date मतलब witness maybe there is only PW1 मतलब
now let the
service
let this
apply here.
let this set up. Yes,
Yes, Your Lordship. In this case, Lordship, petitioner was indicted then for about Lordship more than 3
My
years.
senior, he won't be able to appear
who is your senior?
as Sikayal.
So you are praying for adjournment.
Yes.
But Lordship, he was indicted there for from Lordship 82 to 2020. And Lordship since not very good. last 27/2, since last 27/2 to 2023, Lordship, no witnesses has been examined or produced by the prosecution, Lordship. And the total number of witnesses,
No, let him hear. We have to hear the other.
that is true, Lordship, but when you will come that
After 50 years.
after vacation, not possible. Because, Lordship,
Actually-
this has been listed several times, Lord.
Actually,
I
my
made a
senior,
request
he is
regarding-
busy in some
I
work
made
this
I
week.
made a request to Mr. S.C. Kyle. At least this matter, in this matter, he can appear, Lord. For only for this matter, Lord.
No,
Others matter fixed.
is he in station?
He's in station. He has some personal work. He informed me. In that case, Lordship, he may be accommodated, but during this period, Lordship, before 22, for only for this matter, other or two more matters listed before your Lordship, that maybe they can take adjournment.
And this matter,
This matter only for this matter, Lordship.
but without hearing it.
Lordship must have to hear him. If possible, tomorrow or day after tomorrow, Lordship, maybe.
Won't be possible for my senior lordship.
I made a request to him, Lordship. He agreed for this. I made
Mhm.
a request to them also, Lord. Only for this person, Lord. He is from Assam, Lord, not from outside of.
What is the quantity of contract?
Contraband is commercial, Lord.
How much?
It's 5.150 kg of
From a vehicle, Lord. From a vehicle, 4%, 4% were.
Let it be immediately after the because we have to hear.
Can it
there
be
is-
between last chance, one or 22nd,
No,
Lord?
we have lot of it.
22nd, Lord, for this.
They are saying that on that day may not be.
If
Mhm.
possible, Lord, if time permits, Lord, on that day. Because for this, I made a request to their junior also, Lord, and I made a request to Mr. Kyle also, Lord, for this accused person, Lord.
Immediately on the
Can it be 22nd, Lord?
No lordship. Actually, our
Can
senior,
be,
he won't be
but
able to
unless
come.
the Mr. Kyle appears, I will not.
That is why, Lord, if other two matters are there, I'm not facing on that. For this person, Lord, this is a young boy, Lord, without any involvement, Lord. Only for the allegation, Lord. They are mentally, totally depressed because of this reason, and they are not
No, we
bringing
will
the
not-
witnesses, Lord.
we will not. But after that,
In
May I
paragraph
submit one thing? We have filed our objection. If you kindly go to point number
Four
four,
and
they took, that with regard to the contention made by the petitioner, para 5 contrary to the claim made by the accused, the trial was in continuance that one witness PW7 was present in the court to give evidence on 11/10/2023. However,
11/10?
11/10/2023.
We
However,
need to take time, Lord, on
cross
that day.
examination of PW7
Let's
could
see,
not
let's
be
see the
done
record, Lord.
as Land
Why?
Defense Council,
14
namely SK Narkis, has filed a petition being number 2111/2023 for
okay, we
fixing
will
another.
consider. We will consider.
How many times I have taken the time, Lordship, since 2020, Lordship? How many times I have taken time, Lordship? They have to narrate that things, Lordship. Their objection, they have mentioned this thing.
Whose name? What is the name?
P. Kakolia.
P. Kakulia. Praise God. The council. Listening council for the bad person. On the other hand,
Huh?
Dhanit, counsel for the petitioner has submitted that the petitioner has been detained behind bars since
Since, Lordship, 2022 to 2020, Lordship.
2022 and it will be detained. However, though
What about, Lordship, 3 years, 3 years, Lord, 1,396 days, Lord. 3 years, 10 months, Lord. May I pray to fix the this matter, Lordship? Other two matters, I'm not.
But if 22nd Mr. KL does not come, I will not get. Same thing with, let it be on reopening, let it be on third,
I'll leave it up to your lordship.
on third. Let Mr. Bit on third of
Much obliged.
My lord, in that case, with STCAL, I have one another matter that may be fixed on 35, item number 35, Lord. But I made a request to Mr. Kal regarding that matter, Lord.
no, I have understood, but he's not before. You made a request. He might have given you assurance that he will be present. But these are matters involving commercial matters. So without hearing, even if your case may have a case, 37 is there, I have to hear. So without hearing him, I will not like to consider that. Yes, 35, you take a date,
Any date, Lord.
30, 35,
Yes.
third is
At their request, Lord. Because
yes,
they're
yes, also her. Yes,
Speak with-
speak her good. That's very, yeah, yes. Praise God. God, that's because it's very submission made with God. Very, very,
Much obliged.
any other case where the cat
after making it fix a date, Lord. Otherwise, you will not be available. Again, in every case, Lord.
no,
Not in
we are
every
we have
case.
fixed the date where you have an urgent.
This is also, they are also inside the jail for about 4 years, Lord. In this case, we did not take any time, Lordship. They are not bringing the witness.
You're right. 18
Before people, Lordship.
before we 10.
Like, look,
My lord, here, in this case, I have been arrested on the basis of accused statement. No recovery is made from him. In this regard, my lord, I would like to
This is a charge sheeted case.
no, my lord. Page 14, my lord. Page 14 at the bottom, my lord.
Page 14 of your petition.
No, my lord. Page 14 of my petition. This is the FIR, my lord. Page 14 is the FIR. On the last, the bottom portion, my lord. Accused persons were brought to PS and interrogated. During interrogation, accused person stated that one person, namely Kajol Ahmed Zahir, son of Basaruddin of village Saltora, that me and the Korimgan, who sent them to either to buy heroin. Therefore, the said person was I thought on the basis of this statement, for accused statement, I have been arrested. No possession. And in this regard, my judgment is that my the basis of co-accused statement, one cannot take one.
When were you arrested?
Arrested my on 26, 127 days. 177 days.
So wait for 3 more days.
I thought here I refer to judgment, my
What is the status of the
charge submitted.
charge sheet submission?
Charge submitted charge is April frame. I'm not so far he is concerned, my lord. The apprehended this person said that it was the drugs was to be delivered to him. He ordered. Basically, that is the and CDR etc. My lord, he was, and my lord, this draft was sent by one Manipuri, J. Lalpan Mia. And this petitioner was in contact with the person who carried, and that who arrested person was in constant contact with this J. Lalpan Mia.
No, apart from the statement of the co-accused,
Yes,
Yes.
co-accused, but the CDR is similar. Here. His phone number, from his phone number.
TTR is there.
Yes.
What else?
On a number of, constantly he was in touch with this arrested victim.
The other materials are,
My lord, he was from my district, my, I made contact with him, my, so that, my lord, on the basis of that, I cannot be detained continuously, my lord. These are all co-accused statements, my. And should I be retained, should I be remain in jail, my lord, on the basis of co-accused statement? Where there is the number of judgment is saying that co-accused statement cannot be basis for detention, my. Even in the Madhya Pradesh High Court also is that person is not the owner of the car, not the owner of the vehicle, not the owner of the space, on the basis of only co-accused statement. There is judgment, my lord, I have referred, my lord, there are 10. There are 10, my lord. This Pullubabi, Ahmed, Arimutta, another, my lord. This case,
No,
my lord, Honorable
no.
Supreme Court said,
which judgment you are?
my lord, one Supreme Court judgment and another is Madhya Pradesh.
No,
High
you
Court.
come one by one.
Yes, my lord. One Supreme Court judgment is there. Para 10, my lord. It has been held in clear terms in Tufan Singh versus State of Tamil Nadu, 2021 4 SCC, that a confessional statement recorded under Section 67 of the NTPS Act will remain inadmissible in the trial of an offence under NTPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of the confession, voluntary statement of the respondent or the co-accused under Section 67 of the NTPS Act cannot form the basis for overturning the impugned order, releasing them on bail. The CDR details of some of the accused or the allegations of tampering of evidences on the part of the one of the respondents is an aspect that will be examined at the stage of trial. For the aforesaid reason, this court is not inclined to interfere in the order of 16 November 14 January 2020. That is that High Court denied to bail. Here in this case, my lord, court affirmed that judgment was right made. And this Tufan Singh judgment is there, my.
If there he has gone through that any other material apart from.
One-
No,
On Madhya Pradesh High Court judgment, I clearly say that CDR details and that in that case the accused is not the owner of the car, owner of the vehicle, nor the possession have been made from the from him, my lord. So on that strength, my lord, one cannot be arrested. So granted bail, my lord. MP.
no, but in this case, charge sheet has been paid.
Here in this case also, my lord, the charges have been laid.
Charges are framed
Charges not framed.
against you.
No, my charges.
Anything apart from quick
That co-accused statement and my lord.
co-accused statement is not admissible.
My lord, that is true.
It will not help.
CDR analysis.
TDR will, how it will help, how it shows that
That will be, my lord, wait at the time of, my lord, trial, my lord, after examination of witnesses. The evidentiary value
no,
of that CDR will be, my lord, wait, not, my
But-
lord, in a bail petition, my lord.
no, but it should point out that he is involved in the alleged offense merely because he had spoken to the accused.
So at the time of seizure, obviously, he was not there. It was seized from the possession of this one Ahaduddin and Makbul Hussain. And this petitioner, please, if you have not completed, please carry on. I will sit. Yeah. Continue. Let him continue. I will-
You show me the, in the judgment where CDR was not relied on.
In this case also under para 10, my lord.
In
That's
which
it.
case?
That judgment, my lord,
Which-
the Supreme Court
Supreme
judgment,
Court judge,
Kollula with Ahmed Arimutta and another.
show me.
In this para 10, my lord, it has been held in clear terms of that that a confessional statement recorded under section
That is-
67 of the NTPS Act will remain inadmissible in the trial of an offence under NTPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of the confession voluntary statement of the respondent or the co-accused under section 67 of the NTPS Act cannot form the basis for overturning the impugned orders releasing them on bail. The CDR details of the sum of the accused or the allegations of tampering evidence on the part of the one of the respondent is an aspect that will be examined at the stage of trial. My lord, I will face trial, my. I am from this locality, my. Where I will go, my lord? I will face trial. Every date I will appear. Any condition may be imposed. That will be examined at the stage of trial, whether CDR details is against me or every date I will appear. I am from that area.
Yes, what CDR shows that he,
As per below objection filed by the IO, here he has mentioned the arrested accused person Kazul Ahmed, alias Zahid, had been in constant contact over phone through his phone number 76359217763 with arrested accused person Maqbul Hussain, phone number 69019175773 since 1st June 2023 for supply of the seized suspected heroin.
from where it, how he came to that for supply.
Well, that indicates that during the relevant period when it was said, see, prior to that, he was in constant contact
That is the.
with this Maqbul
For
Hussain.
what purpose he was in? What
For
is
what
the,
purpose he used to explain below.
no, he will not
We,
explain.
we have only, number one, that is a accomplished statement, I understand. So far evidence, that has to be
That
carefully
goes
scrutiny.
totally.
That is subject to careful scrutiny of the court. Then, my lord, for that, my lord, the court will definitely, my lord, look for, my lord, that corroborative evidence. And corroborative evidence other than this CDR, it is difficult to find out in such cases, my lord. That is why what I suggest, my lord, let the search be framed. Thereafter, my lord, your lordship will consider. This prima facie case is there. I will
Uh,
face trial. In every date, I will face trial. If anything is there, my lord, is CDR, that will be examined at the stage of trial. Where I will go, my lord. There, on the basis of the statement of the accused, should I be
heard Mr.
HR?
HR to take.
I understand, my lord, your lordship will certainly look into the right of, my lord, legal right of the petitioner. But at the same time, my lord, a balance has to be struck because drugs is menace to the society, my lord. And huge quantity of drugs have been, my lord, recovered. So with all respect, I submit, my lord, at this stage I have objection. Let the charge be framed. Thereafter, your lordship may.
Who are the other co-accused? How many co-accused?
There are three accused. One is responding, my lord. That Manuburi is responding.
3 accused. From whose possession?
That accused number 1 and 2, current 2, my lord.
How
Page
many
number,
accused?
page number 15, Ahaduddin and Maqbul Hussain. From them,
The contraband with the heard Mr. H.R. Chaudhary, counsel for the petitioner, also heard Mr. D. Das. This application of the section 439 of the Code of Procedure, Common and 73 has been filed by the petitioner namely Kajal Ahmad Jahid, who has been detained behind bars since 26/6/2023, that is for last 107 days, in connection RK Nagar, in connection with special NDPS case number 75 dash the gist of accusation is case that that on which date FIR was not
FIR, my lord, it is lodged on 26th.
on 26/6/2023, one Nilov Jyoti Nath had lodged an FIR before the officer in charge of RK Nagar police station, Karimganj, inter alia, alleging that that an information was received from the- from one Parthapratim Das, who is superintendent of Karimganj, comma, superintendent of police Karimganj, over telephone on 25/6/2023, that huge quantity of drugs were being transported from Hailakandi to Karimganj, and accordingly a team of police staff proceeded toward Isan Tera to conduct a Naka checking. And during the Naka checking process, one vehicle was intercepted, which was driven by Ahaduddin and was accompanied by one Abdul Hussain. During the search of the said vehicle, 200 numbers of soap cases containing suspected heroin were found from the said vehicle. On what was the total weight of the heroin?
Total, my lord, 2 kg, 272.61 grams.
The total weight of the seized heroin was found to be 2 kg, 272 grams. Of the driver and the other occupant of the vehicle from where the contraband were seized, namely Ahaduddin and Abdul Hussain, were apprehended. And during interrogation, the driver and the during interrogation, the apprehended accused person had 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 informed that the present petitioner had asked them to send the heroin had had engaged them to send the heroin to Mysore. Not had sent them to Mysore to buy the heroin. Learned counsel for the petitioner had submitted that the petitioner has been arrested only based on statement of co-accused, which is not admissible as evidence. He has also cited a big state of Tamil Nadu quoted in 2024 page 1, where it observed that statement made by the co-accused cannot be used as an evidence against made by then co-accused under section 67 of the which para of something else?
It is referred in another case in Supreme Court by that, which I referred in Xerox copy, page 10, my. There are 10, my. Another,
Inadmissible. Effect
Pallula with Ahmed Arimutra.
of the state of
And-
state by what state court character court submitted as part of statement of co-accused and here case of the co-accused which only reveals that petitioner had been telephonic contact with the other co-accused person. Nothing is there to implicate the present petition. The offense has been said, hence there is reasonable and hence according to the counsel for the petitioner, the embargo further submitted that the petitioner permanent resident of
Karim-
Karimganj is ready to face trial. On the other hand, the additional public prosecutor has vehemently opposed the grant of bail petition on the ground that quantity of contraband in this case is of commercial quantity and embargo of section 37 company. It further submitted that though it is also fair submitted by the council and additional public that though the statement of co-accused is inadmissible, which however there are CDR cases which lead which point towards the participation of the present petitioner in the offense alleged empire. I have considered submission for there any material earlier case,
Regarding earlier cases, my lord?
earlier,
No, my lord, there is no such.
I have considered the submissions made by the petitioner as well as the petitioner. Though the contraband seized in this case is commercial quantity. However, it appears that the present petitioner has been arrested only on the basis of a statement made by Maqbul Hussain and Ahad Uddin, from whose possession the contraband was seized. As it appears from the ruling cited by that above, but their name may not, therefore, the statement of the co-accused against may not be a basis to come to the conclusion regarding his involvement of his involvement of the offence. As regards media details with concern, though media details of media details of the media details collected by the investigating officer during the course of investigation shows that the present petitioner was in contact with the two other co-accused persons from whose possession the contraband was seized. However, beyond that, there cannot be any assumption as to for what purpose the co-accused were contacted by the present petitioner, as there is no other evidence to link the present petitioner. No other admissible evidence on record at the link the present offence. Hence, for the purpose of consideration of the instant bail application, this court, on the basis of materials available on record, is of the considered opinion that there are reasonable grounds for believing that petitioner is not guilty of the offence involved in it. It is also to be taken note of that there is no material on record suggests that petitioner was involved in similar offences on earlier occasions, or there is no other material to show that if released on bail, he would commit the offence. He is likely to commit any offence while on bail. Hence, the embargo of 37 in the 37 of the NDPS Act, 1985, in the considered opinion of this court, is not applicable. Moreover, the petitioner has already been behind bar since last 107, and he is ready to get back. And this court and for the petitioner is allowed to go 1 lakh with
50,000.
1 lakh with two sureties of like
And
Okay.
compared government employee,
two
Sure.
sureties of like
just one government.
out of which one surety should be the government should be a government employee to the satisfaction of the learned special judge very with following the that number one, the petitioner shall regularly appear before the trial court on each and every date fixed in section case number section in section special case number special NDPS case 75/2020. Any default in appearing before learned trial court without just cause would be a good ground for cancellation of a granted. The petitioner shall not leave the jurisdiction of the learned special judge Karimganj without prior leave of the learned special judge Karim. The petitioner shall not directly or indirectly make it state or no. So as to threat or promise to any person who is acquainted with the facts of this case so as to dissuade such person from disclosing from deposing against the petition in the pending trial. Any other with above of the disclaimer.
Nobody appears.
That none appears for the for let the matter be listed up. Tapi kalau kita ada foto itu ada matter, kadang maybe for the time. Better maybe I don't, but it's after
No, 32. Huh?
it is
The chairs come. I have examined it.
out, Mr. Mr. A. Alam. What's your name? Apple. M. Alam, Learned Counsel for Petitioner. Praise for it. Prayer is allowed. Let this matter with this state after. So, get a text after. For the time.
34. Because at 2. At 2.
Item number 36, 30 submitted.
Appear before the trial. Third, Mr. M. Rana, Learned Counsel for the petitioner. also heard Mr. K.K.
P. Bottom.
P. Bhattaku. And the petitioner prosecutor submits that though the case diary was called for in this case, however, in the meanwhile, charge sheet has been laid by the investigator. Bearing charge sheet number
366/23, dated 27/10/20.
in view of the laying of charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pay for regular bail before that court if so advised.
I plead the FIR lordship, the title of progress is 13 and original on 9.
What is the
Reason regarding lordship that says a finance company lordship, they say that the loan was sanctioned for the battery rickshaw lordship, battery rickshaw. So some person, the petitioner has, the accused person approached their lordship and thereafter loan was sanctioned to 20%. And later on lordship, they found that default in lordship repaying the installment. And after their further inquiry lordship, they came to know that this accused person have sold out that auto that it is battery rickshaw.
who is the accused?
Accused lordship Nilakshi Das.
Only one.
One accused. The mainly allegation is against. Now the question is that lordship, prior to sanctioning the loan amount lordship, they should have verified all the documents lordship. But there is no, they have not made any allegation regarding their fake documents. Fake document allegation is not there lordship. Only says that on believing her lordship, they have sanctioned the loan lordship, taking lordship, not collecting all the documents. It is their fault, lordship. The financial institution lordship, they should have verified the document, the place where the person stays lordship. They should not,
After break.
Yes.
lordship.
Now, so regarding lordship, basically the allegation regarding non-payment of the installment for the sanction loan amount. Lordship. This is the case basically civil in nature, lordship. And moreover, the lady was arrested, lordship, and she is 29 days. And main problem is that she has got a 2-year child, lordship. She is suffering from various ailments now, lordship, regarding that with the mother, lordship. So 29 days, lordship, considering the length of lordship. No. That is why, lordship, due to this separation, lordship, he is
Yes.
suffering a lot.
Otherwise, my lord, in the case diary, there are sufficient incriminating material against the accused. What he has done, my lord.
What?
He has done, my lord. Initially, my lord, introducing herself as a, my lord, official of that NGO. Thereafter, probably good relation with that, because of that good relation of the financial committee, he stated that I am running an NGO for poor people, and thereafter he needs loan on behalf of some of the poor persons of the locality. So without very minimal, without, my lord, going into all details of those documents, you provide loan, and thereafter, my lord, the financial company has issued loan to various persons. Their witnesses statement is also available. Those are, my lord, from Eco Finance e-rickshaw, my lord. And till now, my lord, thereafter, my lord, customers came to know about those loan only when they received regarding notice from the, my lord, financial company. And after that, my lord, now, my lord, statement, what accused person has stated, I would just like to point out, my lord. Statement of the মোৰ নাম জয়ন্ত মই আমাৰ OBC কোটা চৰকাৰী NGOৰ অধীনত ই-ৰিক্সা অহাত আমাৰ NGOৰ অধীনত থকা দৰিদ্ৰ লোকসকলক নথিপত্ৰ দাখিল দিবলৈ কওঁ। সেইমতে প্ৰায় 20জনমান মানুহে মোক নথিপত্ৰ দাখিল দিয়াত মই তেওঁলোকক লগত লৈ ইকো ফাইনেন্সৰ পৰা ঋণ লৈ ই-ৰিক্সা লওঁ, কিন্তু ই-ৰিক্সাবিলাক গ্ৰাহকসকলক বৰ্তমানলৈকে দিয়া হোৱা নাই। বৰ্তমানে ই-ৰিক্সাবিলাক ক'ত আছে মই নিজেও বিচাৰি কোনো সন্ধান পোৱা নাই। So she already taken delivery of those e-rickshaws. Now, my lord, whereabouts of those e-rickshaws, my lord, she herself, my lord, do not know about all those e-rickshaws. So, my lord, she fraudulently, my lord, submitting all those documents before that financing in the name of those, my lord, poor people. She obtained loans from the financial company, and thereafter, when those notices from the financial company,
Who took loan? He
no, in the name of those, my lord, victim persons, my lord, she took loan. And thereafter, my lord, he assured them that you please provide all these documents in your name. I will procure loan from that financial company. Thereafter, my lord, after obtaining the document, the accused person probably taken delivery of those e-rickshaws, and those, my lord, customers, my lord, victims, they are not at all aware about that those e-rickshaws were already, my lord, loan issued in their name. Only when the notice from the financial company received, they came to know about the existence of that loan. And regarding many of the, some of the witnesses, victimized person's statement is also available, implicating the person.
How loan can be sanctioned, lordship, without verification? How loan can be sanctioned?
Her chief need to purchase with a member of the
That is,
No,
the,
what is the allegation against?
that is the content of the
he took
FIR.
delivery of all these e-rickshaws.
How can be done?
Well, your
Not
lordship
just
may
he
kindly
brought all those dummy customers before the saying that they stated that they will get loan from the on OBC. They will get e-rickshaw. And they told them, but that was not informed to us. They came, they signed the document, they even signed the delivery challan, and thereafter the e-rickshaws even gave them 3,000 to 4,000 rupees each of them. We were not aware of that fact. When did the loan remain unpaid?
No, what is the investigation?
Investigation, my lord, she appeared probably her statement, my lord, regarding some of the witnesses, victimized person's statement is available in the case diary. My lord.
No, where?
So, yes, your lordship, I think.
But I have not into the e-rickshaw. There are other persons, so because the loan cannot do all the things. He introduced herself as a member of the government.
Your lordship may kindly peruse two of some of the witnesses, victimized person.
Where are the e-rickshaws?
It's probably she sold to somebody, my
No, why there is no investigation?
investigation probably without, that part, some investigation is regarding what those, because she has not
No.
also disclosed about all
Now
this.
whether her decision, but she has been behind bar.
He is behind the back. He alone has the problem. And now, the 43 did get by her in this. And he now.
No,
gave him-
why have you given the e-rickshaw to one single person when
No, Lord, he brought the dummy customer. He told it that with the papers. Papers are all right. He told them that you get the subsidy from the OPC or ST.
no, you have not verified the paper?
The people they came, they signed the document, but they were informed by her that they are having they will get e-rickshaws from the OPC quota.
Oh.
And she informed us that these are the poor people take the loan, I guarantee, and they will repay the loan. And thereafter, when delivery was taken, they took the
That I have
Well,
understood.
maybe personals of the financial company is also involved, because
maybe
other.
Why have you not verified the credentials of the loanees to whom
the
you-
loanees credentials, not if they produce the Aadhaar card, other documents, these are all right.
Okay.
These documents are of the person, of the victim person. He collected them fraudulently by saying that they will get loan on subsidy. Subsidized loan will be given to them by the government. And these e-rickshaws will be given with the subsidized. He is not alone. There are other persons who are not arrested. And some of the persons have even written to our company. Here they have stated, one Hiren Das, he has stated, বিনীত সম্মানপূর্বক নিবেদন জানাও যে চলিত বছৰৰ জুন মাহত 1/6/2023 তাৰিখে নীলাক্ষী দাস বাইদেৱে মোৰ নামত প্ৰমাণ পত্ৰ ব্যৱহাৰ কৰি কোম্পানীৰ পৰা এখন ই-ৰিক্সা তেওঁ উলিয়ায় আৰু নীলাক্ষী দাস বাইদেৱে কৈছিল যে তোমালোকৰ বাবে NGOৰ নামত ST কোটাৰ চাবচিডি আহিছে, কিন্তু ইয়াৰ বিষয়ে মই একো জনা নাছিলো আৰু নীলাক্ষী দাস বাইদেৱে এই ই-ৰিক্সাখন গোটেই কিস্তিৰ দায়িত্বভাৰ লৈছিল। কিন্তু এই ই-ৰিক্সাখন বৰ্তমান মোৰ হাতত নাই আৰু এই ৰিক্সাখন এতিয়ালৈকে মই দেখা নাই। এই ই-ৰিক্সাখন কিস্তি নিদিয়াৰ বাবে কুমাৰ ইঞ্জিনিয়াৰিং ইকো ফাইনেন্সৰ পৰা কিস্তিৰ কথা জনাই মই কথাষাৰ খবৰ পোৱাৰ লগে লগে নীলাক্ষী দাস বাইদেউক কিস্তি নিদিয়াৰ কথা জনাওঁ। যিহেতু নীলাক্ষী দাস বাইদেৱে কিস্তিৰ দায়িত্বভাৰ লৈছিল, গতিকে মহোদয়ৰ ওচৰত মোৰ বিনম্ৰ অনুৰোধ যে মোক ই-ৰিক্সাখন ঘূৰাই দি উপকাৰ।
No, that is there in
That should be, Lordship, my understanding, what you have submitted, Lordship, that should be an FIR lost by the beneficiary, not by the finance company.
Because
They are basically cases that non-payment of the installment, and that is also civil in nature, Lordship, because agreement is there before filing the Lordship, sanctioning the loan.
non-payment of installment by the loanee.
Lordship, that basically their case, Lordship.
we
It
are
will be a
taking
civil case
litigation against them.
to put
That's
pressurized,
the
Lordship.
procedure. It is different, but the fraud was committed by her. It
No,
is an
no,
organized
what-
crime, and she is the kingpin.
What allegation they have
And
made,
probably
there
some
should
of the
be from the side of
beneficiaries also-
beneficiaries, Lordship, not from the finance committee, because they are lacking is that they have not verified properly.
Lord,
They cannot file a case this way, Lord.
documents
It will
were
be
given
the
to us.
person, Lordship, the beneficiaries will file the case, Lord, saying that cheating has been done to them. Lord.
Lord, because we are the ultimate victim. The
If
entire
they will go for recovery of the installment, Lordship, they have got agreement, they have got Aadhaar card, that has not been manipulated or that's not a fake one, Lordship. Again, each person, Lordship, that documents were verified by them. Lord. The first way, Lordship, cannot detain a person, Lordship. It will be better, Lordship, if the beneficiaries give such allegation on me, Lord. But no allegation is from the beneficiaries side, Lordship. Good. How it when they have put some,
That is not the thing.
Yeah,
That
Lord.
is not there.
basically
The paper.
because of the installment default, Lord, is the case. And 29 days, Lordship, behind the bar. Every beneficiary is not paying the installment, how I can alone take the responsibility?
Lord, because the beneficiaries have not taken the
Their Lordship agreement is, their Lordship non-payment of installment, they have to file civil suit, Lordship, for recovery of the money, Lordship.
What was the arrangement? You pay the money or you would pay, you would procure the e-rickshaw and then give it. What was the arrangement?
arrangement between the beneficiary and the company.
Bank, yes.
No, this finance company, they will give the loan, and then beneficiary will have to purchase that loan amount will be transferred directly to the dealer who will give the e-rickshaw. That was
So
transferred to
dealer
Kumari.
has to deliver the rickshaws to the beneficiary.
Yes.
Now whether it was delivered or
Yes, Lordship, that was delivered. All
Well-
the rickshaws were delivered. I have the teeth, I have an.
That is also there before, Lordship. They have not delivered a particular
but it is
person.
not there with
Not
the IO.
delivered. Well, otherwise, because of my lord, the financial company and both Nilak, my lord, the present issues, ultimately, my lord, these four persons are made kept. Now, financial company will have to file, my lord, petition against the for recovery of that money against those, my lord, beneficiary. So probably, my lord,
The complainant, you cooperate with the IO. If you have anything which IO does not have, provide it. Investigate.
main difficulty is now, my lord, where are, my lord, those rickshaws are now, my lord.
This can be easily located by the
Locate, yes.
Because yes, it's a couple. What? Now,
That, Lordship, what education
No,
is that?
that is not there.
That will
No,
be
that
proved
time
by
we
the
were
allegation
not
by
aware
the
of.
beneficiaries, Lordship. How
Subsequently
the
we
finance
came to know,
company is
because the
putting that allegation on. That is the allegation of the beneficiaries. They will separately file a case, Lordship, criminal case against. Their purpose is to, for the installment only, Lordship, recovery of installment.
Mr. Head. Accounted for it. Also have. Yes, Mr. Kothakut, your final submit, whether custodial detention,
My lord, otherwise only because those, my lord, vehicles are not yet recovered. Only on that ground, my lord. Being
heard Mr. S. Also heard Mr. P. Kothakut, as well as Mr. S. N. Tamuri, Learned Counsel for informed this application under section 439 of the Code of Criminal Procedure Command has been filed by the petitioner, namely Nilakshi Das, who has been detained behind the bar since
2011,
2011
2020.
20 within bracket for last 29 days in connection with Galupadi PSK 635 under section 417, 420, 406 of Indian Penal Code. The gist of accusation against the present petitioner is that on on 28/10/2023, one Pranjal Majumdar, who is the general manager within the finance of Amar Shakti Commerce and Industry Limited, has lodged an FIR before the officer in charge of Jalupari station, interim stating that present petitioner approached the company of the first inform and introduced herself as the key official working for cause of economic upliftment of poor and needy people in Guwahati and adjoining area. And he requested to provide financial assistance to some of poor people selected by her and relying on the assurance of the petitioner, the company provided loan to altogether 20% customers. However, after disbursing the loan, some of the beneficiaries, some of the loanees approached the first informant company and complained that the petitioner took the vehicle herself and did not hand it over the same to the beneficiary. And they also informed informed to them by the petitioner that he would herself repay back the loan. It alleged in the FIR that the approached the petitioner thereafter approached the company of the first informant, assured her that he is ready to stand as co-borrower of the loan, which have which have already been advanced to the beneficiary. And he also assured that he will not repeat such a mistake. However, even thereafter, two other customers were brought by the petitioner to the company of the corporate, who also took the loan in the similar fashion, and thereafter it alleged that the petitioner had sold the several hypothecated vehicles without the information and knowledge of some, and therefore forgery has been alleged. Then a counsel for the petitioner has submitted that informant company being financial informant company dealing with commerce and finance sector ought to have verified the credentials of the loanee to whom the loans were disbursed. And the what is the petitioner is not.
You know, I have taken loan against what Petrica, which I am paying the installment lot. That pays 34 lot. It is the
And
my
the petitioner
installment.
has herself taken loan in respect of only one e-rickshaw,
That pays 30.
in respect of which he is repaying back the installment. And as regards other loanees,
I may introduce them, Lordship, but I am not responsible for their particular.
it is submitted that as regards other loanee, he only. However, he neither stood as co-borrower nor took any guarantee for repayment of loan. On the other hand, the SN Tamuri accounted for submit that the several borrowers have approached the informant company with complaint against the present petitioner that the present petitioners were given an assurance by the that the beneficiaries were given an assurance by the petitioner that he would obtain financial assistance to them through what scheme?
For
Oh.
my lord, by e-rickshaw, my lord.
Under some scheme of the government whereby the beneficiaries would be provided e-rickshaw. However,
Battery operated.
neither battery operated e-rickshaws were not provided to them. On the other hand, learned additional public prosecutor has produced the case diary of Yalupari PS district has taken and has submitted that the investigating officer has in the meanwhile recorded statement of several witnesses, including the beneficiary under section 161 of the It is also submitted that the statement of the present petitioner has also been recorded under section 161 of the KRP, wherein he has stated before that he is not aware as to whether company has delivered the e-rickshaw to the beneficiary after the loan was provided.
There are two statements of the
Learned additional prosecutor has submitted that the e-rickshaws in question regarding which the loan has been provided, where whereabouts of the some of the e-rickshaws were yet not yet known, and in whether that was investigated. That is not the allegation that e-rickshaw
that is realistic.
Here that
by whom.
initially we tried to locate the lead.
But she says that I don't know whether
Otherwise, my lord, it seems, my lord, although, my lord, in this the present case, my lord, it seems to be, my lord, offenses of simpleness, but here in this type of, these are, my lord, very serious types of offense. My lord, although in this case, my lord, in some cases, my lord, even in many cases, my lord, victimized persons initially came to know about any loan, they obtain, my lord, in many ways, my lord, Aadhaar card and all the documents thereafter, my lord, along with, definitely there is, my lord, some help of the, my lord, employee of the financial company is there. Otherwise, my lord, why without verifying any document, they issued loan in the name of those beneficiaries?
no, that has to be investigated.
Investigate. Ultimately, my lord, those beneficiaries, my lord, they made scapegoat, my lord. Because without only because of that, by submitting those documents, my lord, the loan issued in their name, my lord, without their without any, my lord,
No. Now custodial detention is not-
yes, but that's your lordship will have it. Already he is in jail for last 20 minutes.
not
Sir, it may, my lord, can it be included that, my lord, regarding the status of those vehicle is also not yet, my lord, investigated, my lord.
it also it is also submitted by the petitioner of that it appears from the case that status of vehicle e-rickshaws which were to be delivered to the beneficiary not yet investigated. Considering the submissions made by the council, Majot Kotak, that the petitioner also mother of 2-year child who is ill. Mother is ill or child is
The child, because due to separation, the mother is
who has to remain separated from the her mother from her mother due to the detention. Now both as well as considering progress made in the investigation and considering the fact that petitioner has detained behind bars for he has a 2-year-old girl child. This court is of considered opinion that further custodial detention of petitioner may not be necessary if he otherwise cooperates with the investigation. Hence, petitioner Nilaki Das hereby allowed to go ahead of the with that respect, that due to the effect of
Approve metro,
complicated but public. Let her appear
Yes.
before I authorize.
Yes.
With public, that she shall appear for the investigation once every week for next 2 weeks. Or till the investigation, whichever is appear.
2 weeks,
2 weeks or investigation, whichever is appear.
lot.
That she will not, and other two, but that she will not directly or indirectly take interfere or with the above of that this way that effect.
Much obliged, much obliged.
May I please your for intermediate amount is in custody for 96 days.
96
96 days.
cash sheeted.
Charge it submitted, madam. Charge not yet framed.
How much?
47.96 gram of.
Well, there are two parts. 47.96 gram divided by 2 is equal to 23.9 gram per person.
No, no, how much was the
Yes,
47.96.
47 in total. Right, in and rest person is 2 parts. And petition number, accused number 2 is before your lordship. Papori that.
is the lady?
My lord,
From her, my lord, that 47.96 gram, my lord, recovered. And another is.
What else is your submission?
certificate is not extracted, my lord. Take off, my lord. And it was aware of everything. My lord, this husband is accepted. So kindly see the page 33 to 41. All the documents of the
Who is the other co-accused?
Item number 39.
become my lord. Other.
That is also in the list.
Yes.
They were my lord, opinion from the past.
Where the case is pending
My lord, Bihu,
and
Yes,
where,
yes.
Karbi Anglong,
where do you stay?
Lakhimpur. Both are from Lakhimpur.
What is the assurance that you will appear before that?
radio.
Don't, what assurance you are giving that you will appear before that?
But any condition your lord, ready to.
No, what is the assurance that you will abide by?
Elected property because I cannot, I attend the hospital every week or 50 days. I have to.
Okay, heard Mr. M. Rahman. Heard Mr. A.K. Thakkar, and it council for Dr. Keyboard. This application court has been filed by petitioner Srimati Papori Das, who has been detained behind the bar since 15/9/2023 within bracket for last 96 days in connection with NDPS case number 79/2023 pending before the court of London special judge in bracket NDPS case Katia. It is submitted by Senate Counsel for the petitioner that on the basis of an FIR, where is the FIR?
Page 15.
On the basis of an FIR
For-
lodged by one
40 PS case number 97. Page 16 below.
lodged by one Deepak
Lahore.
Dahon, SI opposite before the officer in charge of Port County Police Station comma, and, comma, the court 40 PS case number 97/2023 was registered under section 21B/29 of the NDPS Act against the present petitioner and another co-accused, namely
Pritam
Pritam
Prakash
Prakash Neu, for possession of 47 point
96 from
47.96 grams of
heroin.
heroin. Learned counsel for the petitioner has submitted that the petitioner is a woman and has been stayed behind bars for last 6 days. It is also submitted that the quantity of contraband seized in this case less than commercial quantity, and the embargo of section 37 is not applicable to this case, and the continued detention of the petitioner is no longer required for the purpose of the trial, as he is ready to face trial and he is the permanent resident of Lakhimpur town. Lakhimpur
Okay.
of
Narayanpur. Surabali.
village Jorabari under
Narayanpur PS.
Narayanpur PH. Lakhimpur. It also submitted that the husband of the present petitioner suffering from cancer and is taking treatment of cancer in the Guwahati Medical College Hospital, and due to the long detention of present petitioner, the treatment of the husband has hampered. On the other hand, an additional public prosecutor submitted that
Yes, my lord, finding sufficient material against the accused person.
there
the
are
charge sheet submit-
sufficient incriminating material
My
against
lord, charge sheet not yet framed. The charge not yet framed.
present petitioner in the present petitioner in this case, and though the charge sheet has been laid, the 21B/29 of the NDPS Act, the charges are yet to be framed. Learned counsel for the petitioner, learned additional public prosecutor, has opposed the grant of bail and has submitted that bail may correct the penalty of the charges. However, I have considered sufficient material not to verify scan copy of the case record of EPS. In this case, quantity of contraband is of intermediate quantity, and the petitioner has been detained behind bars since last year. She is a woman and her husband is suffering from cancer. If she cooperates in the trial, her continued detention does not appear necessary. Hence, the petitioner, namely Papuridas, is thereby allowed to go on state of 30,000 with 150 of tax, rupees 50,000 with 130 of tax to the satisfaction of the special judge Guardian with following. Number 1. The petitioner shall regularly appear before the trial as and when so required by the trial and shall cooperate in the trial. What condition you want? This is enough. the petitioner cannot direct the practice of the with head application.
Repeat.
Here 439, please. FIR your lordship will find page 9 and relevant portion for your lordship will find page 12.
It is commercial quantity.
Commercial.
Yes.
Here, just I'm giving the brief fact. The contrabands were recovered from Kalachan Medical Hall. Your lordship will find in the first paragraph,
Page
page 12.
yes.
First line I am reading, lordship. With reference to the subject, I have the honor to inform you that on 5/8/2023 at about 10:20 a.m. information was received from reliable source by OC Badarpur PS that one person, namely Premjit Pal is before your lordship, of Kalachan Medical Hall at Trigori Bazar is selling illegal psychotropic substances in his medical pharmacy. Now just I'm pointing out before your lordship that this pharmacy is not in mine. This pharmacy is in the name of my brother, who is a medical practitioner. On the relevant day, I was only sitting in the case counter, and the lordship will find the document at page 70. This is the type copy which was renewed, and in the second column, your lordship will find late fee there. It is there, and it is valid up to 25/9/2020. If my brother was having valid license, and that your lordship may kindly see page 90. Conditions for the license. MS Kalachan Medical Hall is hereby licensed to sell or stock or to sell stock. So it was stock or exhibit or offer for sale or distribute any by retail on the premises situated at Village Sancho Karimganj following drugs being specified in, excluding those specified in Schedule X. So if it is a Schedule X drug, then that medical cannot keep. And now what we will kindly turn to page 26.
Hmm.
He is my brother, Prasenjit Pal, registered medical practitioner, alternative. And it is not a case that he is disputing the ownership of that medical. Your lordship will find at page 27. He submitted an DIMA application before the trial court as though all the relevant documents were seized by the investigating officer. He claimed to be owner of that farm. Now, if your lordship kindly take up section 68 of NDPS Act,
Section
8. This is the exception in NDPS case. Prohibition of certain operations. No person shall, number 1, cultivate any coca plant or gather any portion of coca plant, or B, cultivate the opium poppy and any cultivate or any cannabis plant, or number 3, produce, manufacture, possess, sell, purchase, transport, warehouse, use, consume, import, interstate, export, interstate, import into India, export from India, or transit by narcotic drug or psychotropic substance. Now, your lordship may kindly note that, except for medical or scientific purpose, except. So now, the drugs which they have seized are medicinal drugs. Those are not manufactured. Those are manufactured. Now, Lordship, I am taking your Lordship to the sixth contract. Page 13, your Lordship will find. Number one, page 13, your Lordship will find. Number one, 18 numbers of steel brown color plastic bottle containing liquid syrup named potent phosphorus. Then 27 numbers of brown color plastic bottle, 10 ml plastic cup containing liquid syrup, potent phosphate. Then your Lordship will find these are all cough syrup. It is mentioned in that paragraph itself. Sodium citrate cough syrup. And number three, 10 numbers of tablet strips. Then 4 numbers of tablet strips, 2 numbers of tablet strips, and 3 number of tablet strips. Zolam tablet. And just I'm relying on for this. On judgment of Honorable Apex Court, here in this case was cross. I am not saying for cross, I am for paragraph 9, Lordship. Paragraph. Considering the small quantity of medicine, here also I have placed that quantity, your Lordship has seen. Most of which are in the category of lotions, ointment, it cannot be said by any stretch of imagination that such medicine could be stocked for sale and would come in the category of stocking of medicines for the purpose of sale. When small quantity of medicines has been found in the premise of registered medical practitioners, it would not amount to selling their medicines across the counter in an open shop. In fact, this is not even the allegation against the appellant. Undoubtedly, the provisions of section 18 and 27 are relevant provisions under the law, which have a social purpose, which is to protect ordinary citizens from being exploited inter alia by unethical medical practitioners. And for this reason, the punishment under section 27 can extend up to 5 years under the law and has a minimum punishment of 3 years. But given the facts and circumstances of the case,
27 is under drug and code.
yes, that is I'm just only on small quantities which were found in the pharmacy law. Because my brother is a medical practitioner, he can keep those only to that extent. But given the facts and circumstances of the case and considering that the appellant is a registered medical practitioner, along with the fact that the quantity of medicines which have been seized is extremely small a quantity, which can be easily found in the house or
What was found in
cough syrup and Zolam. That is for that sleeping tablet.
the case which you are citing?
No, in that case, Lordship, the Lordship will find the column number, serial number, paragraph 3 is there. Paragraph 3, second column and first column, your Lordship will find quantities 1, 4, 9, those numbers.
No, your submission is that being a medical practitioner,
My brother might have kept in his fund. I'm being his brother. I was sitting in the case counter. I was not connected with you. And admittedly, those were recovered from the pharmacy. And if your Lordship see the page 27, my brother also filed Jima petition before the trial court for giving the Jima of those documents.
where it was given.
It was given to it. Because I'm pressing this because they might have said that I am because in the FIR they have said that I am running the fund. Being owner himself, he buy that.
Now, how, what, what,
Section 37, Lordship, if I am not wrong, it says, Lordship, there is ground for believing that he is not guilty. That line I am reading, Lordship. That court is satisfied that there are reasonable grounds for believing that he is not guilty. So reasonable grounds for believing. That already I have told you, Lordship, that the document, that the contraband which was found in a pharmacy, that
Which
pharmacy owner is having a valid license. He is a medical practitioner. He could have, he may have kept those, and even if he keeps that, that is not an offense. So there are reasonable grounds for believing that the present petitioner is not. Because license is valid on the date of offense. His medical practitioner, that is probably will not be disputed by. If they say
you have
that,
like pharmacy license or
yes, my brother is having pharmacy license.
My lord. Well, one practice is going on here is that maybe a license is in the name of one person. He is giving even rent of his license. This practice is going on in Guwahati also, my lord. Pharmacy is running by some other person. He taking rent of that license, my lord, in the name of that person, but running by him. Now, in this case, his brother. As per seizure list, my lord, from the possession of Premjit Pal. At that time, he
where
was
is
there.
it?
Seizure list in the case, my lord.
In here you have got
Seizure list I could not have.
Seizure list, my lord, from the possession of the, from whom seized, my lord, Premjit Pal. That is the petition.
from where
From where seized that
Kalachand.
medical stuff, my lord. Yes. My lord,
Place of seizure,
yes. Several bottles, my lord, yes, all are there, my lord. Bottles, strips, capsules, and all are there. Now, my lord, yes, stock is there in the name of brother. He said, my lord. Now, from the seizure witness also, yes, from at that time he was sitting, my lord, from the seizure witness, independent witness. My lord. Accused person, his statement, he stated that even he is telling, my lord, 2 3 lines I am reading, my lord. So, I understood that I am a pharmacist and yes, interrogation of the expert Premjit Pal. I procured that Korean phosphate and cough syrup bottles from one man of Karimganj. I don't know his exact name as he has never disclosed him to me. I used to sell the cough syrup bottles without prescription. So he acquired that bottle malat without any malat authority, without any any paper. He couldn't. I don't have any purchase slip of those seized cough syrup bottles by police. He don't produce any slips and all this. And he even selling this malat without any prescription. So he is doing this business malat. How can he overcome malat? May see his malat statement.
except that whether any matter, other material is there. But one thing case is there. That statement cannot be the basis for his arrest.
Cannot be, yes, malat at that, this is bail malat, prima facie malat.
That is also applicable in 439 also. That is also observed by honorable effect. In Kholiluddin's case, Kholiluddin's case is also there.
What has
The sheet not
It is
yet
stated,
submitted. It is malat, today is 136th day. Investigation is still going on. FSL is yet to receive malat. No. FSL is that is pending for FSL report and accordingly submission for final from malat. It's almost ready, malat. FSL is not received, but it is dated malat 3/10/23. Malat, we have got the CD on 5/11 malat. Since the CD is asked malat, maybe in the meantime malat, but it is from border procuring was malat. Maybe in the meantime malat FSL obtain malat, but And in the meantime, I will collect more evidence also, matlab, because CD with us from 5th of November. In the meantime, investigation is going on.
Apart from statement of the accused,
Matlab, Caesar witness says that matlab, it is recovered from his position.
from the position, that is, he was present there.
Yes.
But it is from the
So,
pharmacy,
the fact that
pharmacy belongs to
Belongs to his brother. Matlab, he is
brother
doing-
who has
that
license.
is a medical. It is a medical.
matlab,
At this stage, we have arrived at crime of
matlab, yes. It is not a doubt that matlab, the quantity is commercial quantity. He don't have produced any document for matlab, procuring that those matlab, medicine. Matlab. Even his brother also not.
no, his brother is not the accused.
Yes, matlab. Matlab, no document to show that he has purchased those, genuinely purchased those. And he is even matlab, selling without any prescription as per his statement.
Place where from it was recovered belongs to my brother. That is the main content of my argument.
He'll
They are
be-
not arresting him or yeah,
Matlab, investigation is going on. Matlab, 136 days. Matlab, still there is a time for matlab, suspect and further
No, but
investigation.
now, as on, the charge sheet is updated up to by
No, it is up to date up to matlab, 3rd of November. 3rd of October. 3rd of October. And at that time, matlab, as per the IO note, dated 3rd of October, FSL not received. We received the CD on 5th of November. Since the CD is asked. In the meantime, investigation is going on.
how it is.
Matlab,
Yeah.
there are matlab, maybe matlab, there are copies. Matlab.
Supplement.
Yes, matlab.
before FSL. Yeah. So I am not disputing that form. Only thing, if apart
In the
from that
meantime,
statement,
arrest
if
matlab,
anything is
FSL also
there,
received. Matlab, I don't know. Matlab.
No, FSL not.
Yeah.
It is
Maybe some other witness may be examined, matlab, but it was called for, matlab, actually called for on 16th of November. So city,
he was arrested in Lordship in the month of
You take telephonic instruction whether after sending the case diary, whether investigation. Otherwise, we will decide on the basis of the
matlab, maybe fix immediately after reopening, matlab. In the meantime, I'll
I have
Collect-
that in the meantime they will submit. So this case diary may be kept here. I have no objection on that. This case diary may be kept here, and they may call for the supplementary case diary
that report we will call for, matlab.
because they are contemplating as per my instruction, they are contemplating to file the charge sheet to block
So,
in getting this.
so how a person can block the IO to file the charge sheet, matlab. That is also, matlab.
no, then
No.
we have to decide,
Then my case may be decided on
we
the
have
basis
to
of the
decide
materials
on the
available
basis
on the
of the material.
The materials, matlab, yes, materials is up to matlab 3rd of October, matlab.
No, you take
Matlab, yes,
telephonic instruction.
matlab.
We are fixing it on 22nd. That whether the investigation is going on. Regarding FSL, assuming that FSL is positive.
Yes.
We will consider the case of the petitioner on the basis of the available data. Your
Well-
submission is that some other evidence may also be
May
collected.
also, matlab, yes,
So you take telephonic instruction.
matlab.
If some other evidence is collected, then we call for that. Otherwise, we will decide not to day after.
Maybe fix on day today also. Maybe fix on day after tomorrow, matlab, from Gorakhpur, matlab, I'll matlab, verbal instruction, matlab,
Verbal instruction.
no, in such case, matlab, it's difficult for us, matlab, NDPS case.
So
matlab,
you take written communication.
WhatsApp or written, matlab, and email, matlab. Maybe
Uh,
fix on Thursday, matlab.
Okay.
Maybe
Friday.
Friday.
Okay,
Thursday, matlab.
third, Mr. A. Ahmed, that answer for also heard Mr. A.K. Parashar, edition of Senate Council for the petitioner has submitted that, that the contraband seized from the possession of three contraband allegedly seized from but in fact it's from the pharmacy of the brother of the
Offensive. Page 22, occupant offensive.
Prasenjit Par, who owns the Kalachan Medical Hall, which is situated at Sri Gauri Bazaar, from where the state contraband is. And counsel for the petitioner has also submitted that the petitioner brother being a registered medical practitioner of alternative medicine and the Kalachan Medical Hall being a licensed pharmacy, the brother of the petitioner is legally entitled to keep small quantity of the medicines which were recovered. It is further submitted by the counsel for the petitioner that the petitioner was only sitting in the pharmacy when the contraband was seized in the absence of. On the other hand, the petitioner has submitted that the petitioner has himself stated that he was selling the coated cough syrup. Is further submitted that case diary is updated up to the 3rd of
3rd of October.
3rd of October. And the meanwhile, the investigating officer might have collected other evidence which may be independent in nature and which could explicate the present. In view of submission of the Senate additional purpose, he is requested to take a report from the investigating officer of whether is 199 by telephonically informing him as to whether the other materials have been other materials have been collected against present
Present.
petitioner. In addition to what already available at this matter on
21st.
21st of get a copy of this order one case diary be retained.
Written on the top.
Case diary be retained till next day.
Okay.
You are the pharmacist, brother.
No, no. One, we took arrested of the
We'll take it up when it comes.
To issue, my lord, can it be taken up? Niharika's judgment was referred. And after Niharika's judgment, Lordship, there are other three judgments that the only judge I will read that. Lordship, convenience.
Finish within 15.
Within 15 minutes. Because facts are already very much clear, Lordship. There are three FIRs. One FIR already charged has been, sorry, FR has been submitted, Lordship. And subsequent two FIR, Lordship, within these two petitions are challenged, where the charge sheet has been filed, and in one, with item 6, Lordship, the wife of the informant, Lordship, is also an accused who filed subsequently another complaint case. And now, for your kind consideration, Lordship, for information, Lordship, as my instruction, Lordship, the wife is with the earlier husband, Lordship, my landed friend, and he is appearing both these two, Lordship, wife as well as husband. Lordship, I already referred, Lordship, Shambhu Karwar versus State of Uttar Pradesh, Lordship. That judgment copy, Lordship, I have, Lordship, may I supply the same again? Or I took the file, I think they are. Or I will supply the for the time. After Niharika's judgment, Lordship, that judgment was delivered by the Honorable Apex Court on 12/8/2022. In that judgment, Lordship, paragraph 6,
Statement. Which
Lo-
para you are saying?
I am relying paragraph that may become from 5, Lordship. It is also quashing of FIR, Lordship, under section 482. Honorable High Court has rejected and that Honorable Apex Court set aside and quash the FIR as well as the further proceeding, Lordship. And one thing I am clarified, Lordship, this judgment is delivered by two judges bench. Within that, Lordship, the Honorable Chief Justice was there, in which the Niharika's case was also decided, Lordship. In this judgment, Lordship, paragraph 5, page 2, Lordship,
Para 5 you are saying,
I am relying just I am giving the sequence, Lordship,
but which para you are
6, 7. May I read some line, Lordship, of that which may clarify? Apart from the above, it is significant to note that the second respondent was granted a divorce by mutual consent of the order and dated so and so, so and so. The parameters governing the exercise of the jurisdiction of section 482 CRPC are well settled and have been reiterated in a consistent line. Paragraph 7, Lordship, I am reading. Consistent line of decision of this court in Niharika's concern, a three judges bench of this court, which one of us was a part in the present case, reiterates the parameters laid down by R.P. Kapoor versus State of Punjab as well as State of Haryana versus Bhajanlal. These two, Lordship, held that while the court ought to be cautious in exercising the powers under section 482, they do have the power to quash. The test is whether or not the allegation in the FIR discloses the commission of the cognizable offense. The court does not enter into the merits of the allegations, but turns upon the powers of the investigating agency to investigate the allegations involving in the commission of the cognizance. Paragraph 8, Lordship, the Bhajanlal case, which has referred, I am relying also that, Lordship. Lordship, in this court formulated the parameters in terms of which powers in section
No,
482 of
this para does not help.
Lordship.
This para does not help. This
Lordship,
para says that if the FIR discloses an cognizable offense,
Lordship. Now only second paragraph, Lordship. That is, where a criminal proceeding manifestly attended with a malafide. I am on that, Lordship. And where the proceeding is maliciously instituted. By respect to submission, Lordship, the informant has filed first FIR, Lordship, which is ended as Lordship FR, and stating all the details, Lordship. There is no case was made out in the kidnapping charges, Lordship. With the ulterior motive of wreaking vengeance of the accused with a view to so and so. Lordship. Then, Lordship, also paragraph 8 and 9 also. Then Lordship, lastly, in the special contest, Lordship, paragraph 11, then paragraph 12, Lordship.
Yes.
My response, they are a consensual relationship, Lordship. Long term, Lordship. Then, Lordship, paragraph 13, Lordship. In this paragraph, taking allegations of the it is impossible to find out the FIR at the charge sheet, the essential ingredients of the offense under section 376. That is third case, next case, Lordship. That is item 7, Lordship. The crucial issue which is to be considered as to whether the allegations indicated that the appellant
Which
had
para
given
you are reading?
paragraph 13, Lordship.
Where?
Page 6, Lord.
Yes.
Got it, Lordship. The crucial issue is to be whether considered as to whether the allegations indicated the appellant had given a promise to the second respondent to marry and which the instructions was false and on the basis of which the second was induced to the sexual relationship. Taking the allegations in the FIR and the charge sheet as they stand, the crucial ingredients of the offense under section 375 are absent. The relationship between the parties was purely a consensual nature. My respect to some kindly note that, Lordship. The relationship as noted was existence prior to the marriage of the second respondent and continued in substance during the term of the marriage. Then next, Lordship, the High Court, that I am not on that, the High Court has then subsequently analyzes the fact that stated stand are not in dispute to indicate that the ingredients of the offense under test were not established. The Honorable High Court has therefore proceeded to dismiss the application is completely misconceived basis. We accordingly allow the appeal and set aside the appeal judgment of the High Court in application so and so. The 482 shall be accordingly stand allowed. The case of so and so registered so and so, charge sheet so and so in the aforementioned case and order so and so in the court of so and so, taking charge sheet shall accordingly stand quashed. Then, Lordship, another judgment, Lordship, it was decided on 8/8/2023, Lordship. I'm just after Niharika's judgment, Lordship, Muhammad Ali and others versus State of UP by the Honorable Apex Court. Lordship. In the state case, Lordship, paragraph Lordship, paragraph 11. Here also, Bhajanlal case, Lordship, paragraph 11 discussed, Lordship. Then, Lordship, the next page, Lordship. I am relying on Lordship 3, Bhajanlal 3, 5, and 7, Lordship. Where the allegations made in the FIR or the complaint, Lordship, ground number 5, Lordship of the Bhajanlal, Lordship, next page, paragraph, page 12, Lordship. Absurd and inherently improbable on the basis of which no prudent person can never reach a just a conclusion that there is a sufficient ground for proceeding against the accused. Then again, Lordship, clause 7, Lordship, I am relying, which I already referred, Lordship. One also, Lordship, timing, Lordship, we can give where the allegations made in the first information report or the complaint, even if they are taken at their face value, acceptance in their entirety do not prima facie constitute any offense or make out a case against the accused, Lordship. Then, Lordship, paragraph 12, Lordship. Middle portion, Lordship. At this stage, we would like to observe something important. Whenever an accused comes to the court, invoking either the inherent powers under section 482 of the Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution, to get the FIR or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious, instituted with an ulterior motive for wreaking vengeance, and then in such a circumstance, the court owes a duty to look into the FIR with a care and little more cautiously. Then after 3-4 lines, Lordship, in the FIR or complaint are such that they disclose the necessary ingredients to constitute allegation of a thereof. It will not be just enough for the court to look into the aberrations made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the allegations of offense are disclosed or not. In a frivolous or vexatious proceeding, the court owes a duty to look into many other attending circumstances. Why I am reading, Lordship, 164 statement as well as in the record of Ken copy, Lordship, 161 may kindly peruse of that about the her statement. Emerging from the record of the case, owes and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising the jurisdiction under 482 of CRPC or Article 226 of the need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation registration of the case, Lordship. Lordship, it is the page 14, Lordship. In the state judgment, Lordship. Take of the instance of the case of multiple FIRs. What I am on Lordship, in our case, multiple FIRs, 2 FIRs are there, Lordship. Take, for instance, the case on hand, multiple FIRs have been registered over a period of time. It is in the background of such circumstances the registration of multiple FIRs assume importance, thereby attracting the issue of wreaking vengeance. My respected submission, kindly consider that, Lordship. Wreaking vengeance out of a private or personal grasp as LS. This portion I am relying, Lordship. Lordship, then also paragraph 13(1) judgment will be referred in the next page, page 15, Lordship. Page 15, Lordship, subclause 5 of the quoted judgment, Lordship. Authority of the court exists for advancement of a justice if any attempt is made to abuse that authority so as to produce injustice. The court has a power to prevent such abuse, Lordship. Then last line, Lordship, R.P. Kapoor, which Honorable Apex Court relied on that earlier judgment, Lordship. R.P. Kapoor versus State of Punjab, AIR 1960, Supreme Court, Lordship. Paragraph 6, subclause 6, Lordship. Roman 3, Lordship. Bold portion, Lordship. Where the allegation constitutes an open part, there is no legal evidence adduced or the evidence adduced clearly, manifestly fails to prove the charge. Lordship, then next page, Lordship. Last, Lordship, paragraph 14, upper portion, Lordship. It is judicial process, no doubt, should not be instrument of oppression or needless harassment. Court should be circumspect and judicious in exercising discretion and should take all relevant facts and circumstances into consideration before issuing process, lest it would be an instrument on the hands of a private complaint or to unleash vendetta to harass any person needlessly. This is the judgment, Lordship, I am relying. Then, Lordship, last one, Lordship. Just I am,
One FIR has been lodged by wife,
Lordship,
another by the
husband. First one also by husband, Lordship, where FR was first one. Where FR,
You are against the later FIR.
Lordship. 2 later. Last judgment I am reading just, Lordship, for business, Lordship, because time is also very short. I want each also, with all respect, Lordship, because of your Lordship accommodation several days we have taken. In the state judgment, Lordship, it was decided on 31/8/2023 by the Apex Court, Lordship, in Abhishek versus State of Madhya Pradesh. In that judgment, Lordship, I am relying on paragraph 12, 13, 16, 17, 22, and 23, Lord. Just I am coming, Lordship, on paragraph 12. The contrast of the powers of quash criminal proceeding under section 482 are well defined in B. Ravi Kumar so and so 19. Affirm that they are the accused, where an accused seeks quashing of the FIR invoking inherent jurisdiction of the, it is wholly impermissible for the High Court to enter into the factual arena to adjust the correctness of the allegations in the complaint. Then Lordship next, three judges Niharika's case come to the Lordship point. Three judges bench of this court elaborately considered the scope and extent of the power under section 482. It was observed that the power of quashing should be exercised springly with the circumstances in the rarest of the rare case. Such stand not being confused with the norm formulated in the context of a death penalty. It was further observed that while examining the FIR, public complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise the allegations made therein. But if the court thinks fit, regard being had the parameters of quashing and self-restraint imposed by law, more particularly the parameters laid down by this court in R.K. Kapoor versus State of Punjab, as well as the State of Haryana and others, where the Niharika's goes judgment, Lordship, elaboration was there based on R.K. Kapoor's case and State of Haryana versus Bhajanlal case. In the instance case, husband, family members, then next a petition for quashing a criminal proceeding launched against them by his wife, Mrs. So-and-so. Disputes are neither a rarity nor a recent origin. Apart from the scope, we may not take some decision of particular relevancy. This court had an occasion to deal with a similar situation where High Court had refused to quash a FIR registered on various 419. Lordship, then paragraph 16 may come, Lordship. I am not taking much time, Lordship. Paragraph 16, therein it was observed that when an accused comes before the High Court invoking either the inherent powers under section 482 CRPC or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR of the criminal proceeding quashed, essentiality on the ground of that such proceedings are manifestly fabulous, vexatious, or instituted with a ulterior motive, wreaking vengeance. Then such circumstances, the High Court owes a duty to look into the FIR with a care a little more closely. It was further observed that it will not be enough for the court to look into the aberrations made in the FIR or complaint alone. There's some deliberation is there, Lordship, for the purpose of ascertaining whether the necessary ingredients to constitute the allegation offense are disclosed or not.
This judgment you have already cited.
Lordship,
Um,
that is Mahmood Ali and
Understood.
other purpose, Lordship.
Understood.
Just I am relying on that. Then Lordship, Bhajanlal's entire things are there, Lordship. And then given to the last paragraph, paragraph 22. Given the totality of the facts, and we are of the considered opinion that the Bhajan's allegations against the appellant, further there so and so are sufficient grounds for proceeding against them. In effect, the case on hand falls squarely categories 1 and 5 out set out in Bhajanlal, permitting the criminal process to go on against the appellant in such a situation would therefore result a clear and patent injustice. This was a fit case for the High Court to exercise its inherent powers under section 482 to quash the FIR and consequential proceedings. The appeals are accordingly allowed. FIR was quashed. Lordship, just I am coming only, I will take only 2-3 minutes, Lordship. The final report, Lordship. I am just reading of that, Lordship.
Of the first FIR.
Past FIR.
First FIR.
Past FIR. Though I filed affidavit, Lordship, but it has not come to the record. I am supplying the copy of the same. Lordship. Entire things of subsequent FIRs are coming, Lordship, in the FR.
No, you have filed additional affidavit.
Lordship.
Has not.
Lordship, already I filed it on 15/12, Lordship. It may be, Lordship, in the filing section or coming, Lordship, but because of which, Lord, I am supplying for convenience of this honorable court, Lordship. Lordship, It may be annexure A, Lordship, page 137, serially. There is the first FIR, Lordship, against where the alleged victim has made a statement under section 164 supporting the petitioner, Lordship. May I read, Lordship? 137. The brief of the case is that on 39/2020 at 8 p.m., complainant Anisul Islam Choudhury, son of so-and-so village, lodged a written FIR at this PS to the effect that on 29/9/2020, in the morning, his wife, namely so-and-so, saying that they would visit the house of a relative. In the late evening, when they did not return home, he contacted the state relative and came to know that they left the relative's house at 2:30. Thereafter, he started searching to them. In the later hours, the accused Nurul Huda so-and-so,
The first FIR was filed by the husband.
Lordship,
The wife supported her statement under
164, correct,
That is your
Lordship. And which I might ask to submission all subsequent FIR just because of which I have reading that FIR portion, Lordship. Entire case, Lordship, touching that because complaint petition as well as her it is in the present FIR about the mention about the earlier FIR, everything. Subsequent FIR coming with the things where his wife is also an accused. My respect to submission, since Lordship, their wife returned back with him. Everything, Lordship, there is no chance of any conviction, Lordship. Just I am subsequently he realized that the persons have been during investigation on the same date at night, children so-and-so was recovered. Then, Lordship, after 3-4 during medical examination, Jasmine Begum Lashkar was recovered for her medical examination and treatment and recorded her judicial statement under section 164 CRPC. At Hailagandi Court, during medical exam, victim refused to medically examine. On that day, Lordship, with all respect, I am referring one judgment of that, Lordship, while any victim is refusing, Lordship, there cannot be any charge of 376, Lordship. Lordship, the victim stating that her judicial statement that she was married with complainant Anisul Islam Choudhury about 14 years ago. After her marriage, her husband Anisul Islam Choudhury tortured her physically and mentally, and she was tolerated the harassment. She gave birth to two so-and-so. About 1 year ago, her husband pronounced talaq upon her, and since then she is staying separately in her husband's house. But her husband tried to forcibly by physical with her on various occasions. Meanwhile, she met with, that is the present petitioner, Lordship, in her husband's office. They developed friendship. And about 4-5 months ago, they started love affair. She told him about the atrocities by her husband. That is the informant, Lordship, and assisted him to marry her. She has assisted, Lordship, for all these wrongdoings, Lord, with all respect, with all fairness and submitting, Lordship. She is a major, Lordship. So the consensual for part is there, Lordship. Marry her on her request to elope on 28/9/2000. She took her younger son with her so-and-so, call her. She sent her son so-and-so. She does not want to go with her husband, Anisul Islam Choudhury, that is the present informant. She is living peacefully with Nurul Huda Barbuya, and Nurul Huda Barbuya accepted her despite all her problems. My respect to submission, considering that, Lordship, in course of the case from the judicial statement of the victim, it was learned that the victim, Jasmine and her son was not kidnapped by Nurul Huda Barbuya. Evidence was found insufficient against FIR name accused person. Under the I beg to return the case in FR as evidence insufficient for this purpose. Lordship, after filing this FIR, then again the informant filed second FIR
on 6/10/2020, coming with
What
same
happened?
FR.
It was
FR is,
accepted.
Lordship, I think, no,
After submission of FIR, notice will go to the informant.
Lordship, no notice to the accused, there is not, we have now,
What-
no, with
what
all
is the
patterns.
status of the FIR?
To that part, Lordship, I cannot, I may be allowed to take information tomorrow, Lordship, I'll ask her that it there, Lordship. Oh, but, you know, Lordship. So these are the Lordship. I am trying to not to repeat everything, Lordship, because I already demonstrate before your Lordship, and
Mr.
Lordship is kind enough to consider that if my landed friend is saying anything, if I need to, I submit my reply.
My lord, so far, my lord, I have understood from the submission of my landed friend. He is, my lord, denying, my lord, that there is no rape, there is no kidnap of my lord wife. Leaving aside that, my lord, assuming, my lord, prima facie, my lord, his submission is correct, my lord. There was no kidnap, there is no rape. But he has not, my lord, exhibited or enact any document that there is a typo. And my lord, he also stated that, my lord, there was a marriage, and admitting, my lord, now, my lord, this woman is staying with the, my lord, with her original husband, my lord. So, my lord, if that is so, my lord, if he fails to show that, my lord, any breakup between their marriage, subsequent marriage, alleged marriage, my lord, there is no document. And he has not tried to, my lord, take her back, my lord, as wife, my lord. But they allege that, my lord, they already married, my lord. And, my lord, earlier marriage, without, my lord, breaking earlier marriage, my lord, and proof of divorce, there is also, my lord, serious allegation, my lord, as per section, my lord, 497, adultery, my lord. There is a, my lord, section 497, and punishment is provided, my lord, 5 years, my lord. Undisputed, my lord, aspect I beg to, my lord, and I am trying to bring the
497.
497, my lord. Adultery, my lord, 5 years punishment, my lord. I am, my lord, I am, my lord, trying to bring to the notice of your lordship the undisputed fact, my lord, still remain, my lord. Assuming he is correct, my lord, some submission is made. But apart from that, this, my lord, lady, my lord, my lord, son was also kidnapped, my lord, and subsequently police recovered, my lord. If he has, my lord, married another, my lord, person and eloped with another man and admittedly married, then, my lord, she has no right to keep my lord, this son, my lord, minor son, my lord, with them, my lord. And police recovered and handed over the son to the petitioner, my lord. These two facts are still, my lord, remain undisputed, my lord. And even, my lord, there is no proof that there is a, my lord, divorce of earlier marriage, my lord. And, my lord, there is no proof, my lord, that, my lord, subsequently, my lord, there is any, my lord, talak or, my lord, break of, my lord, marriage subsequently. No proof, my lord. My learned friend is, my lord, arguing as if, my lord, he is not committed, my lord, rape. He has not committed, my lord, kidnapping of the wife, my lord. Maybe, my lord. But assuming, my lord, leaving aside these two allegations, my lord, still, my lord, remain, my lord, serious allegation against him, my lord. Undisputed allegation, kidnapping of the minor son, and, my lord, adultery. Now, lordship, kindly have a look. I beg to, my lord, draw the attention of your lordship to the provision of the, my lord, 482, my lord. 482, my lord, it is, my lord, quoted in the, my lord, by the legislature, my lord. When, my lord, there is a, my lord, no case at all. And prima facie, my lord, this is, my lord, a false case, my lord, and prima facie, my lord, do not constitute, my lord, repeatedly, my lord, Supreme Court and Honorable High Court, my lord, holding that, my lord, there is a no case at all, prima facie, my lord, after reading the FIR, my lord, then case may be quashed, my lord. And, my lord, my learned friend, my lord, referred one judgment, my lord. In this judgment, my lord, referring all previous, my lord, judgment, even then, my lord, Supreme Court quashed one 376 case, my lord. I have gone through this judgment, my lord. Paragraph 12, it is provided, my lord, by the Supreme Court, my lord. My lord, my learned friend, my lord, relied one judgment. This is Shambhu, my lord. Paragraph 12, lord, kindly have a look. Supreme Court held that, my lord, it is impossible to find any ingredients in this case regarding rape, my lord. Therefore, my lord, this case was quashed, my lord. Page paragraph 12, my lord. It is provided paragraph 12, my lord. In the present case, the issue which had to be addressed by the High Court was whether, assuming all the allegations in the charge sheet are correct, as they stand, an offense punishable under Section 376 IPC was made out. Admittedly, the appellant and the second respondent were in a consensual relationship from 2013 until December 2017. They are both educated adults. The second respondent, during the course of this period, got married on 12 June 2014 to someone else. The marriage ended in a degree of divorce by mutual consent on 17 September 2017. The allegations of the second respondent indicate that her relations with the appellant continued prior to her marriage, during the subsistence of the marriage, and after the grant of divorce by the mutual consent. In this backdrop, and taking the allegations in the complaint as they stand, it is impossible to find the FIR or the charge sheet the essential ingredients of an offense under Section 376 IPC. Therefore, my lord, because in this case, my lord, fact of this case is that, my lord, 2013 to 2019, my lord, these two, my lord, men and women were in relationship in this judgment, my lord. And in the middle, my lord, she also, my lord, married elsewhere. And, my lord, continued, my lord, relationship. Then, my lord, it was divorced on mutual consent, my lord, and relationship still continued. Then she, my lord, suddenly filed one FIR, my lord, after 7 years. Therefore, Supreme Court held that, my lord, there is nothing regarding, my lord, rape. Therefore, my lord, it was quashed, my lord. Therefore, my lord, in the facts and circumstances, this case does not, my lord, match with the facts and circumstances of the present case. Lordship, now kindly, I just, your lordship, show the provision of the, is a very limited and special provision, my lord, before your lordship, 482. 482 provides, my lord, saving of inherent power of the High Court. Nothing in this section, in this code shall be deemed to limit or affect the inherent power of the High Court to make such order as may be necessary to effect any order under this code, or to prevent abuse of the process of code, or otherwise to secure the interest of justice. So, my lord, very important power, very special power, my lord, but in a very, very, my lord, narrow campus, my lord. When, my lord, there is no, my lord, case is made out, and your lordship is 100% satisfied, my lord. This case has nothing to do by the trial court, my lord. Definitely, your lordship can interfere with the, my lord, this all the bad, my lord, complaint or case, my lord, before the trial court, my lord. But here, this case, my lord, my learned friend, time and again, my lord, alleging that, my lord, there is no rape, no kidnapping. Leaving aside that, my lord, from the face of the, my lord, complaint, my lord, it is page, my lord, 23, my lord, FIR sought to be, my lord, quashed, my lord. My lord, may I read, my lord?
Come to the relevant.
Yes, my lord. Here, my lord, entire, my lord, this is very precise, my lord. With respect to the, my lord, just I, Anisul Islam Chaudhary, would like to state before you that on the date of I had a file case in a Hailakandi PS so regarding the kidnapping of my wife and minor child, who was recovered on so-and-so date by police, but was unable to find my wife, and accordingly today after the recovery of my wife, the police and produced her before the court along with some marriage documents, and from that it came to my knowledge that the document relating the marriage which were submitted in the court, that the accused number 1 Nurul and so and so in connection with the accused number 3 and accused number 4, namely Komrul Hussain Borboia and Abbas so made a conspiracy and prepared my lord marriage affidavit and a notary declaration certificate of marriage so as to deceitfully induce a belief in wife that she has lawfully married accused number 1 so as to cohabit with accused number 1, which is illegal and an offense punishable under the penal provision of law, and also accused number 1 made a conspiracy including my wife to stole away a sum of rupees 1 lakh from my house, which I kept for some business purpose in a safe place in my house. But on searching, I realized today that it was not there, as I was busy in finding my wife, accused number 2. Moreover, during subsistence, my lord, this allegation is also there, my lord. During subsistence of our marriage, my legally married wife, namely accused number 2, Jasmine Begum, knowingly that I am alive and have not given her any form of divorce, married accused number 1 and living with him as husband and wife in an illegal manner. Besides it, my wife has willfully deserted 2 minor children on age about 8 years and another 2 years, causing them a huge mental trauma, and even my younger child, who is just 2 years age, was victim of her cruelty as he left him abandoned near Shifa Hospital, from where the police recovered my son. As such, I therefore request you to kindly initiate stringent proceeding of illegal cohabitation, bigamy, theft under penal provisions of law, as well as under section 7 of Juvenile Justice Act. This is a, my lord, complete, my lord, fair and specific allegation, my lord. And very, my lord, penal provisions are involved, my lord, specifically. Thereafter, my lord, another FIR, wife subsequently lodged, my lord. He has, my lord, a challenge in the second item, my lord. This FIR, he also, my lord, for ready reference annexed in this petition also, my lord. And this FIR, my lord, just I am, my lord, citing, my lord, relevant portion on page 58, my lord. My lord, paragraph 2, 3, my lord. It is our case, my lord. My learned friend is praying for, my lord, quashing of this FIR in the second item, my lord. Paragraph 3, my lord, that the accused was also running a private business along with the husband of the complainant, and in the pretext of it, he used to visit the house of the complainant on and off, and also used money and to do paperwork. Then suddenly on one day, that is on 2/6/2020, while the husband of the complainant was away and the accused took the advantage of the situation, went to the complainant on the false pretext that he wants a paper which needs to be signed as a guarantor to the bank, made her sign a few papers relating to bank, which seemed quite usual to the complainant, as she earlier also used to sign papers. But the accused, taking this advantage, made her sign and blank stamp paper, which later turned out to be a forged marriage document, which was made in collusion with accused number 3 and 4, which was kept in concealment and dark from all. So, my lord, I am not going, my lord. Some other serious allegations are, my lord, also there in the subsequent paragraph 4 and 5, my lord. up to, my lord, paragraph 6, my lord. This is full of, my lord, allegations in this case, my lord. And lordship, your lordship is aware, my lord, this is a settled principle of law, my lord, all along, as on today, my lord. When, my lord, prima facie case is made out, my lord. My lord, lordship may not, my lord, be pleased to, my lord, exercise power under section 482 CRPC, my lord. But my learned friend, my lord, shying away to contest the case, my lord, before the trial court, my lord. And he is, my lord, trying to satisfy your lordship by citing the contradiction, my lord. So far, my lord, from my little, my lord, experience, I have understood, my lord. But all these things are, my lord, as per my humble understanding, my lord, this is 482 petitions, my lord, this all my learned friend's argument is not maintainable, my lord. And, my lord, I have already, my lord, cited earlier, my lord, here, my lord, one, my lord, Niharika Infrastructure, private, my lord, this is Honorable Supreme Court judgment, my lord. Under, my lord, paragraph, my lord, it is my lord, provided, my lord, authenticity, my lord, of the, my lord, complaint, whether true or correct, my lord. Yes, my lord. My lord, under, my lord, paragraph, my lord, 23, my lord. 23 and more specifically, my lord, 5, Roman 5, my lord. Paragraph 23, Roman 5, my lord. Just, my lord, small paragraph, my lord. While examining an FIR, my lord, complaint, quashing of which is thought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR complaint, my lord. My lord, this judgment I have earlier occasion I have provided. Then, my lord, in the affidavit, my lord, I have submitted another judgment of our Honorable High Court, my lord. This is, my lord, last, my lord. 126, my lord. Turning page, my lord, 126, my lord. Yes, my lord. Paragraph, my lord, 4, my lord. Small paragraph, my lord. Kindly I may be allowed to read out, my lord. Paragraph 127, page, running page, paragraph 4, my lord. Before entering into the merit of the petitioner's case, it is necessary to point out that the law with regard to the quashing of criminal complaint of FIR is no longer res integra. A Ketinam judicial decision has settled the position of law on the aspect of the matter. I may refer to the case of so-and-so, so-and-so, AIR, so-and-so, wherein the question which arose for consideration as was whether a first information report can be quashed under section so-and-so and so-and-so. The court held on the fact before it that no case for quashing of the proceeding was made out, so-and-so, my lord, so-and-so. However, observed that though ordinarily criminal proceeding instituted against an accused must be tried under the provision of the code, there are some categories of cases where the inherent jurisdiction of the court can and should be exercised for quashing the proceeding. One such category, according to the code, consists of cases where allegations in the FIR or the complaint, even if they are taken at their face value and accepted in their entirety, do not constitute the offense alleged in such cases. No question of appreciating evidence arises, and it is a matter merely of looking at the FIR or the complaint in order to decide whether the offense alleged is disclosed or not. In such case, this said the court, it would be legitimate for the High Court to hold that it would be manifestly unjust to allow the process of the criminal court to issue against the accused. From the case of so-and-so, it becomes abundantly clear that when a mere look into the contents of the complaint or FIR shows that the contents thereof, even if taken at their face value and accepted to be true in their entirety, do not disclose commission of offense, the complaint or FIR as the case may be what. Now, my lord, this impugn complaint was entirely, my lord, quoted by the honorable judge, my lord, and ultimately, my lord, it is a 498 case, my lord, and it was held that, my lord, prima facie case is, my lord, made out, and criminal petition under section 482 was denied, my lord. So, my lord, as per my humble submission is that, my lord, these two FIR, my lord, very fairly, my lord, and very innocently, my lord, described all the, my lord, facts and circumstances of the case, my lord, and, my lord, prima facie case is made out. Then, my lord, prima facie also, my lord, charge sheet is also submitted in those cases, my lord. But my learned friend is, my lord, not willing to contest the case to prove his innocence before the learned trial court for the reason best known to him, my lord, and filed this petition before your lordship, praying for, my lord, quoting of these two cases, my lord, before your lordship. This is my humble submission.
Only his reply to page 79, lordship, of the lordship, it is a charge sheet, lordship. Page 79, third paragraph. Moreover,
IO has made an observation.
IO has made it. And apart from that, lordship, apart from 164 statement, lordship, she has filed an application for her custody, page 37, typing copy. Original is page 39 in my petition, where she has categorically stated about that, lordship, she has page 37 to lordship original up to page 41.
What we have said.
Lordship, I read, lordship.
No, you
In a-
just said what.
Lordship, she has stated that she was never kidnapped. In that petition, never kidnapped, it is unnecessary to mention that the petitioner already got talaq, lordship, and well-wisher performed the marriage and is accused as her husband and wife. Then 164, lordship, it's very categorical, lordship. My respect to submission, lordship, the first FIR is the continuity of second and third FIR, lordship. Lordship, yes, first FIR, lordship, while police has investigated the entire thing, lordship, and submitted FR, lordship. I don't know, lordship, about that, lordship.
Will derive, my lord, that if
Lordship, whatever may be at this stage, he will revive. This is not the question, lordship, since it is not there. I am, with all respect, lordship, all these two
No,
FIR.
what is the submission?
my lord, regarding this, my lord, I have no specific instruction, my lord, perhaps because they are, my lord, very, my lord,
And regarding,
given very important to the case, my lord, definitely they will take, my lord, court of law, my lord, regarding this already filed FR, my lord, my learned
What's
friend.
that?
FR regarding one case, my lord, FR was submitted, my lord.
And
They will take, my
regarding-
lord, report
regarding-
of that case, my lord.
regarding adultery, lordship, part, lordship, I am unmarried, lordship. There is no question of adultery, lordship. And that adultery or bigamy not in the FIR or charge, lordship. Police has not submitted any charge, lordship, of that. But my learned friend is trying to debate the case by saying all other things, lordship, which is not on record, lordship. With all respect, lordship, I am submitting it is a completely an abuse of the process of the court. My learned friend is taking so easy, lordship. Both of them are, entire thing is that they were on business, lordship. They have taken away money and now again reversing way. My learned friend, client is an informant, lordship, false informant, husband, lordship, taken away the money, tortured his wife, and they had a release, lordship, which already established, lordship, in 164 statement, lordship. There is no prima facie case is made out in the state to FIR, subsequent to FIR. The third one is the complaint, lordship, complaint case filed by the victim, lordship, alleged victim, who is an accused. So that cannot be hard. 164 statement cannot be before the honorable court, lordship. With all fairness, I am submitting without fear or favor, lordship. She has stated everything before the honorable court under 164, and now coming with a different plea, lordship. Can it be possible, lordship? So my submission, there is no such charge, lordship, which is stated, lordship, and I have given relying on the judgment of the apex court as well as the contention made by the honorable apex court in Bhajanlal case, lordship, as some points of that I am relying on that, lordship. So my learned friend is other way trying to divert the things like that. With all fairness,
Okay.
just one word. Last, my lord. My lord, my learned friend, all the documents delight, my lord. And my lord, record, my lord, all are, my lord, not, my lord, absolute, my lord, all are, my lord, matter of debate, my lord, and cross-examination, etc. is also necessary, my lord. Once it is say, my lord.
Third, Mr. K. M. Sir, that's not the first. Both common or both. Also, Mr. K. M. Board Member Republic. So learned counsel for the petitioner has submitted that petitioner has filed that petitioner affidavit on 12/15/2020. Same not for that the petitioner brought hearing completed.
March. Keep look. Taken enough time for
No, you are helping us. Betul. Itu tak. Affidavit. Paper.
Particular. The 439 application, Lordship. The petitioner was arrested on 27/2/2022, Lord. Appears at page 90. Thereafter, Lordship, in this case, after investigation, charge sheet submitted, Lordship, under section 120B, 201, 121, and 121A IPC, graduate section 18, 18A, 18B, 19, 20, 28, 29, 40 UAPA. Thereafter, Lordship, what happened? I have filed a additional affidavit. Cognizance taken. Thereafter, during the hearing of the charge has been
Charge was filed.
under section, Lordship.
Charges frame.
Charges frame
Under
13. Lordship, 13 of UAP Act, graduate section 121, 123, 153, 153A, and 153B. And also, Lordship, 120B and 37 IP.
121.
123, 153, 153A, and 153B IPC, then graduate section 120B and 37.
Report.
Not 34, Lordship, 37. Then, in this case, Lordship, bar is under or the chapter 4 and 6 under section 43 UAP Act.
UAP.
Yes.
D5.
43D subclause 5, Lordship. Yes. In this bar is no person of accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody, be released on a bail or on his own bond, unless the public prosecutor has given an opportunity of being heard on the application for such release, provided that the accused person shall not be released on bail or on his own bond, if the court, on perusal of the case diary or the report made under section 173 of the Code of Code, is of the opinion that there are reasonable ground for believing that accusation against such person is prima facie true. So this bar is not, and this is under for 4 and 6.
Chapter 4.
6 and 13 is under chapter 3. The punishment for 13 is prescribed in the act is, Lordship, punishment for unlawful activities.
So 43D5 is not applicable.
Yes. So I have bring it to the,
Why trial court rejected your,
that time that petition was not filed because before framing of,
after framing of charge, you have not moved.
because this was pending before Division Appeal Court, before
So
framing.
after framing of charge, you
No,
have
Lord,
not moved the bail application.
No.
court.
So that is why it was pending before.
When were you arrested?
I was arrested on 27/7/2022. And in this case, Lordship already granted bail to the other accused person before framing of charge. That is at page 85. All the persons got bail, Lordship, from High Court. I could court, Lordship.
How many days you are behind the bar?
I'm behind the bar for about, Lordship, 1 year, 4 months, 16 days, Lordship, about 504 days.
1 year.
And no witnesses examined till today, Lordship. That's it. Witnesses are yet to be examined.
Now why that? There is no bar. 43D bar is not, that is not the,
Lordship.
how many, against how many persons charges were framed?
Oh, again, all persons.
How many accused were there?
9, Lordship.
9 out of 9, how many are on bail
All are on bail except
except? What,
yes, are yet to be examined, Lordship. After that,
let him also test. Because the bar is not,
Lord.
now for detaining you, you have, must have some ground that he may flee away or he may influence the witnesses. Is there any,
with some stringent condition, Lordship, you'll have to appear each and every day, Lord.
hard with S can appear,
And my objection may be also.
hard, also may make this application court at 9 of 5 staff of the staff at same bar. It will step for last 1 year. How many days?
510 days.
For last 510 days. Connection with special case number 4 that it pending before court of the session that we the extension case court paragraph which may paragraph court of only 3 on receipt of the FIR Mirabari case 156
Lordship, I will be able to put that.
Ah.
Okay.
investigation for ultimately on completion of the statute was laid against how many
9.
against 9 accused persons, including present with under section 18.38 that of the assault activity investigation and 120 submitted by the Which charge? Which charge?
Charge, I have filed additional affidavit also along with that.
Page?
His lordship in continuation of it,
When the charge was made?
charge was framed on 18 November, lordship, 18/11/2023,
That
page
counsel-
109, lordship.
counsel for submitted that on 18th of February. That court had framed charges against all the accused. However, at which page
114, lordship will find the last paragraph. lordship.
against all the accused. Under section 13 of the subsection and section 121 that that one minute that against all the that as section as section 13 of the and all chapter 3 of the Act Commandment. The embargo of section 40 within bracket chapter 6 within bracket Roman 5 of State Act is not applicable as offense the 13th State Act. It is also submitted by an offense for that all the other have been, this I can, I'm not verifying
Yes, yes, all the accused.
all the have at last state. That is not but that it has operate that and faith that 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 something of that there is no keeping of prolonged for about 500 days. The other hand, that opposed grant of faith not the fair heart against and against that is considered by the one and of your faith because faith God as there is no embargo grant of faith within of framing charges and other provisions of mighty within and as other co-accused are already faced. This court does not find it justified if within other continue within if the otherwise cooperate trial in the in view of above it is Safa area thereby have no way of sale of 30,000 security of site subject to 30,000 with two security, like subject to statement that break with following that statement that operate trial in the trial, I think in the trial of sentence case number 4 that I think for court of the shall appear for trial as and when qualified by trial. The petitioner shall not directly and indirectly or not the petition during pendency of the trial of session special case or of the petitioner shall not leave the state of Assam without prior permission of the above of the state.
Keep your
Two pictures Equatorial Lordship. And petition number 1 was arrested on 28/1/2022, my lord. And petition number 2 was arrested on 25/11/2021. In fact, my lord, charge sheet was laid on 22/2/2022, my lord. And thereafter, on 1/6/2023, charges were framed. And only 2 prosecution witnesses, my lord, has examined till date, and they have not supported, my lord, the case of the prosecution, my lord, as regards that. I have annexed, my lord.
But there are other,
My lord, I will,
and your incarceration not long,
it's already, my lord, 2 years, 24 days, my lord.
2 years, 24 days.
Yes, my lord. Petition number 2 is behind the bar for 754 days, my lord, as on today. It's an FIR of 25/11/2021, my lord. Page 11, Lordship, the kind my lord. 13 is the,
No. Petitioner number 1, Shakir Hussain,
he was arrested, my lord. He was even not even present at the place of occurrence, my lord. And thereafter on 28/1/2022, my lord, Zakir Hussain was arrested from his house. And 2 was arrested, my lord, on 25/11/2022. So they are both, but my lord, together, my lord, that's why we have,
the number 1 has completed how many days?
he has completed, my lord, 1 year, 10 months, 22 days, 690 days, my lord, as on today.
And number 2,
2, my lord, he has completed 2 years, 24 days, that is 754 days, my lord, as on today, my lord.
now how many witnesses are examined?
My lord, 2 witnesses only examined, my lord, till
Yeah.
date.
They have not supported.
They have not supported, my lord. They have been declared hostile, my lord. We have annexed, my lord, their statement, that is evidence, my lord, page 24 is the
What
evidence
was seized from
my lord, actually, prosecution case is that, my lord, they received an information that at the house of one Dilwar Hussain, my lord, some drug dealing was going on, and they reached this place, my lord, and it is alleged that Ali Hussain, my lord, the petitioner number 2, they could able to apprehend, and petitioner number 1, along with Dilwar Hussain, they fled, my lord, from the place. So that is the, my lord, case of the prosecution. Page 30 is the FIR, my lord.
Page?
Page 30 is the FIR.
No, from whose possession the
My lord, it was
silver
Dilwar Hussain's house, my lord.
and you were also present,
My lord, they say I was also present, my lord.
both of you.
As part of the prosecution, my lord, as part of the FIR, my lord.
And what was the seizure?
It was 930 grams of 2000, 930 grams of tablet, my lord, methamphetamine. This is page 14, my lord.
200 tab.
Yes.
Yes.
My lord,
Long and cut.
Long detention, yes, but there is reason. This one accused was there was arrested on 28th January. Now one accused is absconding. For that reason, my lord, though charge sheet was filed, my lord, in the on 22 to 22. 22nd of February 2020. Now, my lord, one accused, Dilwar Hussain, he is also one of the prime accused. Or he was absconding, and for completion of the process to separate his trial, some time was consumed by the court. Now, formal charge was framed on 1/6/23, and within 2 months, 2 PWs have been examined. So it cannot be said the trial was delayed due to any lapse on the part of the prosecution.
But there
And perhaps I have update only till 30th of August 2023. And after that, what happened, I do not know. I may be 1 or 2 instances have been examined. No, it is able. That is all right. That is also good.
what is
for
the
you.
latest matter?
My lord, I have taken instruction, my lord, last week also that no witnesses conduct it.
So my respectful submission is that there is no
Lapse on the prosecution.
no left.
There is no lapse on the right
Excuse-
accused.
That I understand, my lord, but they have committed a heinous crime, my lord.
My lord,
The allegation is serious, my lord.
from
That
the
is
record,
menace
my
to the
lord,
society.
from the record, I could find, my lord, that on many occasions, summons are not even issued, my lord. Number of occasions. That was there, my lord, in the record. In fact, on 21/12, my lord, court directed the office to immediately, my lord, take the summon upon the accused, Dilwar Hussain.
On which judgment?
My lord, maybe that officer, Dilwar Hussain is also there, my lord, and my lord, that is another, my lord, coordinate that the judgment, my lord, Shahjahan, my lord, where, my lord, the witnesses did not support. They were with the police, my lord, as per the as per the FIR, my lord. So, my lord, court has granted them bail, my lord. That is the very fundamental fact of conscious possession is absent.
No, that whether that aspect can be, that aspect we will not do it.
Delay
That-
aspect.
Delay aspect.
Delay.
we can-
Delay, my lord, that remains that, my lord, I am behind the bar for from 25/11/2021, my lord, till date. And no lapses of, my lord, it is not the case that because of these accused persons, trial was delayed.
Heard it, name, date of- of- Yeah. This application 439 court has been filed by name Jakir Hussain against Kabir Hussain and Adi Hussain, who are in are
28/1, my lord.
28/1
Two.
and 25/11
25/11/21, my lord.
28/1/2020
Two is the first petition.
22.
Yes, my lord, petition number 1, my lord.
Second one,
Second one, 25/11/2021, my lord.
second one
Yes, my lord.
has been read 25/11
One.
one respective in connection special previous case 119 that pending before the court of that special jurisdiction, which has arisen from other cases 7/7/1 the list of inquisition case that on date of affair
24/11/2021.
on 24/11/2001
One.
one Jotindra
Sin-
Sinha, SI of that lost and fire court of the judge profession of charity that on receipt of an information table showed that some prohibited drugs are concealed in the house of a silver saint in the village Jangla 2 under Uttarakhandi police station. A search operation was conducted and 930 grams of blue of W WY tablet containing methamphetamine. What was the content?
Methamphetamine.
Methamphetamine was seized therefrom. The present petitioner had taken from place of Senate counsel for the petitioner had submitted that the petitioner number one, Jakir Hussain, has been detained in guard for last 600, whereas the petitioner number Ali Hussain has been taken in guard last 754. However, till now, the witnesses, only two witnesses have come and they have also declared that not supported. But support further submitted that that the petitioners are entitled to get paid it is mainly ground of prolonged incarceration as observed case of as observed by the apex court case of India and for state the city of Delhi voted subject to the effect as well as be prepared for the
State of Purit.
state of Pisa. What is the citation? State of Pisa significant order dated 13/7/2000 passed in special leave for this significant exception number 4169 that the stuff submitted by the council that fixed court has observed in the aforementioned cases that prolonged incarceration overrides for further submitted by the council for that both the are within government and they face prior to the public exam. On the other hand, Senate petition of on the other hand, the Senate has vehemently opposed grant of bail the present on the ground that quantity of contraband is is of commercial quantity, and therefore the embargo of Section 37 is applicable to this case. He has also submitted that though the incarceration of the present petitioner is withdrawn, however, is not at fault for this in any manner, as the prosecution, as the trial got delayed, as there was another co-accused, namely Mohammed Dilwar Hussain, who was shown as an absconder that and to split up the case of the Dilwar Hussain from the case of present petitioner. Some time was required by court. He has also submitted that charges that may or be and thereafter witnesses are already done. Therefore, there is a likelihood. How many witnesses are there?
9 witnesses, Chairman.
Two witnesses are already done. There is like other witnesses of which had also been done. There is the opposed grant of bail. I have considered the submissions made by the counsel for both the sides and I have gone through the scan copy of case record of special NDPS case number 119. It is available for though, this case involves commercial quantity of contraband. However, considering the fact that the petitioners are detained behind the bar for more than 2 years, the question before this court is that as to whether the prolonged incarceration of the petitioner in this case outweighs the embargo of Section 37 of the NDPS Act 1985. So, if this court comes to a finding that the delay is long enough so as to come to the conclusion that such a delay has outweighed the embargo of Section 37 of the NDPS Act, and the petitioners can no longer be detained behind the bar due to the fundamental right guaranteed to them under Article 21 of the Constitution of India, they may have to be released on bail, spite of that. It appears that though the prosecution was not entirely at fault for the delay caused in the trial of this case, however, it also appears that the petitioners are also not at fault for the delay of the trial, as they were detained behind the bar throughout the trial. The petitioners have a right to get speedy trial under Article 21 of the Constitution. Then quote paragraph number 12 from Burhan bail application number 3486 paragraph number 12, paragraph 13, 14, 15, 16, each and case of as the petitioners have been detained behind the bar for last 690 and 750 days respectively, and only only two witnesses have been examined by the prosecution side, and they have testified, and 7 more witnesses are yet to be examined by the common. The trial is unlikely to complete soon, and therefore this court is of considered opinion that in the instant case also the long incarceration of the present petitioner has outweighed the embargo of Section 37 of the NDPS Act, and therefore the above are set to get bail. In view of above, what was 47?
What?
What was Peter?
930 grams of white pepper.
View of above, the petitioner above named the petitioner namely 21 are allowed to go on bail of 50 with the possibility of like one of whom be a government employee should be a resident of state of Assam to the satisfaction of such trial with following 40 Quran with above bail.
Patient case number 119 of 2021.
That what
Keep it.
bail what is there in item number 22? This is an updated item.
Yes.
Upgraded.
As per order dated 5/12, last date, you stated that prayer for interim order. Completion of the circuit appeal. But SN number has did the first type. Approximate time the comes matter page 17. Next array. Here,
No, who is for the other side?
the forest,
They have
I have intimated on the last location they are present, minutes at first present.
if they come, I will take up. Till then, we will take up after. We'll call your bail.
Up to the
May please lodge.
66 here received my
Charge sheeted case. So, what is the offense?
Offense, my lord, 120B, 420, 468, and 471. FIR, my lord, says
You have been shown as an absconder.
absconder.
Summons are issued against.
Lordship, someone issued, my lord, for various second,
Thereafter,
before appearance.
then you appear.
Out of 5, my lord, initially, my lord, what happened, my lord, we approved the small court. This
This is not a case for 38 because trial court will give you bail.
as well because we have been shown absconder, my lord, in the start sheet.
No, still
Look.
your apprehension,
And here, my lord,
because trial court is competent enough to
Lord.
grant bail
Lord.
for all the offences.
lordship. Only, my lord, initially, my lord, we approved this all court. And this all court, my lord, granted interim, we have cooperated with the investigation. And out of 5 accused, my lord, in 2 separate bail petitions, my lord, bail of 2 petitioners, my lord, were
No, you were granted interim bail.
lordship.
Earlier granted, later on, rejected.
Our bail was rejected and
Case 39, rejected.
But how, why 438? Why 438? Why you apprehend that you will be?
Earlier,
my lord, in the start sheet, my lord, we have been shown absconder on the because, my lord, the honorable court, my lord, rejected our bail. And in the start sheet, my lord, the IO has clearly mentioned that we cooperated in the investigation.
You
Our
convinced
statement
the
has
trial-
been recorded.
You appear for trial court and
And only application, my lord, absconder, we have been shown absconder. And judgment of honorable Supreme Court, my lord, Aman Preet Singh, my lord.
that's my word
no,
is
okay.
absconder, but actually he is
But
fleeing
trial
from.
court has committed no error.
No.
Trial court has issued
no.
summons to you.
Yes.
And there is every likelihood that trial court would consider your
Yes.
Lord.
bail.
Because one of the person who is also, whose bail application was
that-
also earlier rejected, trial court has granted him bail.
No,
Right.
this is okay.
Nine
Because
five, my
this
lord,
will come into play if trial court would have issued non-bailable warrant of arrest, which trial court has not done.
in another ground, my lord, another point has been settled by the Supreme Court, my lord. Roman 5, my lord. The court shall, on appearance of the accused of non-bailable offence, who has neither been arrested by the police or investigating agency.
Will allow you to go on bail.
Lord.
You convince trial court.
Because as my lord, I have been shown absconder only.
The word absconder is used, actually fleeing from justice. Otherwise, there is no other word. Except so police has
the
write the
start
word
sheet-
as absconder.
The start sheet,
But that does not mean that
It has been
trial
reflected,
court
my
has
lord.
declared him
Lord,
as an
Mr.
absconder.
R. Ali, that is counsel for also Mr. P. Court of Application of this application, the 438 of the Code of Criminal Procedure, 1930, has been filed by petitioners, namely Habibul Talukdar and Rashidul Khan, who are apprehending their arrest connection
after 5
Yeah. PRC case,
on bail.
PRC case number 2665/2020, arising for the case 9 the section 120 slash 4 slash 470 slash 34 of it. Planet Council for the petitioner has submitted that though the Senate trial court has issued summons to the present petitioner, and when the date is fixed
8-1.
and the next date fixed, 8/1. However, as the petitioners are shown as absconded, that they apprehend that on their appearance for the that they may be detained behind. So, done it, hence, pray that a favorable order of the Court of Appeal may pass in favor of.
Cooperate with the petitioner.
On the other hand, done an addition, but there does not appear apprehension of being detained by anyone. There does not appear present connection here that as regarded trial court has only someone attended and has three other poets. I have considered the it appears that the, the provision of Indian Penal Code under which charge sheet has been made does not put any embargo on the trial court grant bail to the petitioner on their appearance in person to the, on their appearance before it in person to the summons received by the petitioner. And the apprehension of being detained by apprehension of being arrested by of the apprehension of being detained by being detained on their appearance before the magistrate of the present petition does not have any reasonable basis. Therefore, this application for 438 the petitioner may appear before the trial court person summons by bail and may pay for regular bail for the trial on their petition.
There was 439 person was arrested. Along with it, item 38, it is going.
Real Wasi has already allowed item number 30.
There is no recovery from my
Heard Mr. L. Mohan, Senate Counsel for the petitioner, also heard he brought up the petition of this application for section 439 of the Code of 1973 has been filed by the petitioner, namely Pritam Prakash Dev, who has been detained behind the bar since date of arrest is 14/9/22. How many days?
96.
Since 14/9/23, within brackets since last 96 days. In connection with period 79/20 under section 21B/29, the list of expression is section number
38.
38. Then it counted for what is the sub?
Thing has been recovered the under the I was traveling in the vehicle.
Counsel for petitioner has submitted that
Jointly recovered that those were
that though each contraband has known is jointly from as well as the other poet, namely what the name of
Papuri Das.
Papuri
Das.
Das. However, submitted that the contraband was concealed
47.96
contraband that 47.96
96
gram
gram
of
of heroin.
was concealed the undergarment of poet and poet and the present petitioner was only traveling a vehicle with the court. Otherwise, also submit that the petitioner is a permanent resident of village Anisbari, the Tatu police station, of Pittur district, and he shall operate in the trial and shall appear for trial if allowed to. On the other hand, an additional the petitioner has produced
And here it is.
submitted that so what you are opposed
Yes, well, I'm opposing because charge not yet came from the joint position of the those
submitted that this contraband was recovered from the joint possession of present petitioner as well as co-accused. And there are sufficient criminality here and charges are yet to be. On that ground, the petitioner has opposed the charge of it. On the other, I have considered the submissions made by the petitioner as well as petitioner, and have perused the scanned copy of case for 79. Considering the fact that property that has already been allowed to go on paid application. But it also considering the fact that the petitioner has been detained behind the bar since for last 96 days. His further custodial petition does not appear to be necessary if he otherwise if he cooperates in the trial pending trial of which indicates case number 59 that pending for the court of Senate Special Judge Karbiang view of a petitioner thereby allowed to go on bail
Official Judge Deepu Karbian.
of 50,000 with one theory like subject to Karbiang with positive 38 positive. With these observations, bail application.
May please open. FI lordship will find on page 8. That's it.
Case diary not.
So can you Friday lordship? Absolutely lordship, as per the FI it says lordship is an attempt lordship, and thereafter the forwarding report says that this person was in telephonic contact with the person present there. Absolutely no election against the president.
Know whether they will be able
Right. I will try. Chalo koi.
to say any or who prays for another state for producing it. Where is the love? Let this case be set again with second before
It is a lordship. Lordship on last petition directed to check the records of criminal petition 765 to 350 matter. Here in case pilot, I am behind the bar for 619 days for alleged for recovery of 15 kgs matter. It was recovered from the luggage compartment of the passenger. And since, my lord, there was another person from Bihar who was traveling, my lord, and there was from his possession 8 kgs were recovered. The prosecution, my lord, clubbed together and filed a FIR, my lord, showing it to be a commercial quantity. And my lord, the co-accused earlier, my lord, approached court, my lord, for passing of the charges which were already, my lord, allowed. The charges were passed, my lord, and he was also granted bail, my lord. Since the court came to a finding that the recovery, alleged recovery is only of 8 kgs, my lord. So the section, part of section 37 is there, my lord.
How many days you are,
But 619 days, my lord. As on
then they cannot be
Already your
charges
lordship
have
has,
been
yes, already
What?
your lordship has passed.
heard. Mr. M. A. Chaudhary, counsel for petition, also heard the report of additional public prosecution. This application of the section 439 report of has been filed by the petitioner, namely Kamlesh Yadav alias Kamlesh Pancham Yadav, who has been detained behind the bar since last
619 days, my lord.
since 9/4/2020
Nine-
to 22 within bracket for last 600
19 days.
in connection with special SPS case number 56/20 arising out of Bajadi Sera PS case number 64, which is pending in the court of Planet Special Judge Karim. Planet Council for the fact relevant for consideration. No, the gist of accusation in this case, in brief, are as follows. It's from criminal petition number 7. Utul Vedap. Yeah, Bhagat Vedap. It's copy the, you have the order of bail,
Bail application, I have annexed, my lord.
which where
It starts from page 41, my lord.
bail petition, bail order,
Bail order of Mr. Kumar is annexed.
Mithilesh.
Yes, my lord. Page 41 of my petition, my lord. Present petition. Page 41. Annex 6, my lord.
Yes, this quote from page 42 of Learned Counsel for the petitioner has submitted that though the charges were framed by the learned trial court on 18th the section 20B 29 of the NPPS Act, 1985, read with section 34 of the Indian Penal. However, in criminal petition number 765/2023, this court, by order dated 7/12/2023, has quashed the said charges on the ground that the
Paragraph 46 of finding of court, my lord. In 7 criminal order passed in criminal petition 765.
on the ground that only eight, only 15 point, only 8 ganja was seized from the possession of the Koik village and 15, how much?
15 kg, my lord.
15 point,
My lord,
15 kg ganja was recovered from possession of the present petitioner, Kamlesh Panchapyat. And though the both the present petitioner and the Koik were traveling in the same, there is no material or report that there was a connivance or conspiracy between both the persons, namely the judge, and therefore the charges, therefore the contraband cannot be treated, contraband seized cannot be treated as of commercial one, and on that ground the charges framed under Section 20/29 against the present petitioner, the co-accused, was quashed. Considering the fact that the petition of that view of the quashing of charges, the quantity of ganja present may not be treated as commercial. Considering the fact that the order of framing of charges against the present Section 20B/29 of the NDPS Act read with Section 37 of the Indian Penal Code,
34.
34 of the Indian Penal Code has already been quashed by this court by order dated 7/12/2006, passed in criminal petition 765/23, and also considering the fact that quantity of ganja from present was only much
15 kg, exact.
was only 15 kg, which is less than commercial quantity, and therefore the embargo of the Section 7 is not the instant case, and hence the continued detention of the present petitioner
1 year, 8 months, 10
for
days.
last 1 year, 8 months, 10 days does not appear to be justified. This court also takes into consideration the fact in view of the above fact, the petitioner is the above named petitioner is hereby allowed to go on bail of 30,000 with 2 local securities of like amount, subject to the satisfaction of with following conditions same from page 4. It is after bail.
Keep the
May please the Lord. Lordship, I was granted interim in this case way back in February, 9th of February 2023.
submitted.
That is submitted. You have appeared before the IF.
Lordship, within 1 week, the charge sheet has been submitted against the petitioner. Lordship, the prime accused happens to be different. He was behind bars for 45-50 days. I was not arrested. I am the maternal
It is
counsel
not
of the
specific, my lord, whether against the present accused, only
What is your name? Kothari.
Yes.
Heard Mr. D.K. Kothari, learned counsel for the petition. Also heard Mr. P. Kothakot, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was allowed to go on interim anticipatory bail by order dated 9/2/2023, and within a week of the date of the said order, he had appeared before the investigating officer and has cooperated with in the investigation. On the other hand, an additional prosecutor has submitted that though the case study was brought forth, however, the meanwhile, the investigating officer has already laid the charge sheet bearing charge sheet number
94/23, dated 31/3/20.
considering the fact of laying of the charge sheet, considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the above named petitioner, namely Satyalal Mahato, is by this court on 9/2/2023 is hereby made absolute with a condition that is hereby made absolute. With this order, that
Keep your.
The 430 applicant, there are 3 petitioner out of the 2 were lady matter. Their interim bail was granted and their statement has been recorded. And my lord, all of the kindly page 18 is the FIR, my lord. Page 18, my lord.
Yes.
Page 18, my lord. There are 3 name accused, my lord. All of them are before your lordship. With due respect, I have the honor to inform you that above mentioned person forged my signature and would like to state that I have not issued any sort of certificate to them. Their certificate are fake certificate and never issued such certificate having my tenure of the Gaumbu of the Damdama Howard is the kind of information necessary. Accordingly, my lord, 420 and 468 cases in register. These 3 petitioner, my lord, they are selected for my lord RCCC training course, my lord. That is, my lord, record certificate class course training. That is called Mandal training. So, my lord, their certificate of the my lord, residential certificate of that particular village of Dima Hasao was reported to be forged by the complainant. So, my lord, after granting in bail, my lord, they will appear and the statement has been recorded. And probably that statement was not with the seat in last occasion. That's why they were asked for you the up-to-date seat. So now, my lord, whether up-to-date seat is
Yes, well,
all 3 were granted in the
all 3 were granted, they appeared.
statement recorded, my right? But from the case diary, my lord, they are cooperating with the investigation, but there are implicating material against the accused. Because my lord, allegation is that my lord,
The Gaumura said that he has not issued that.
he has
That
not
is right.
issued the certificate, and my lord, they are not actually the permanent resident of the Dima Hasao district, and on the basis of that certificate issued by the Gaumura, they took admission for undergoing that training course.
What is the progress of it?
The statement they are cooperating with it.
Heard Mr. P.J. Mohan, in it, state by P. Sharma, Senate Counsel for the petition. Also heard Mr. P. Bodhaku, petitioner. Senate Senior Counsel for the petitioner has submitted on 29/9/2023 all the 3 petitioners, namely, what were allowed to go on interim and prepared by the court. And thereafter they had appeared for investigating officer and have cooperated in the investigation. On the other hand, the petitioner of prosecutor has produced the case diary of Maibong PS case 21/2020 and has submitted that the petitioners have appeared before the investigating officer and their statement under section 161 of the Code of Conduct have been recorded. Considering the fact that petitioners have complied with the directions of the court and have cooperated with the interim bail granted the appropriate petitioner by order dated 29/9 by this court is hereby made accepted with conditions number 2 and 3 attached to the said order.
Keep your,
This said
keep your.
Lordship, the Alliance Committee with on
Item number 45, traffic submit.
you are on interim bail. You appeared before the investigating. Have you have you appeared before the investigation? Whether the petitioner had appeared, can you take this information over telephone? When you're taking
Well, traffic submit.
then we are making it a third means. But for that you have to make a submission that
Yes,
you have cooperated.
Yes.
That much is for
I will get them.
third means as
on
the as the praise for an adjourned the ground that the conducting Mr. S. R. Pupar, who is the conducting counsel of the case, has some personal difficulty. Considering submissions made by the counsel, that this case is listed on 21 February 2000.
No, 46 also my case diary not received. He is on interim.
Third, Mr. M. Z. Shah, that third, the Board of who praised for some more time for producing case that the prayer is allowed. That is
On 12/1.
12 on the interim order.
Item number 47 and 48, my lord. Although petitioners are on interim, my lord, regarding one accused person, it didn't need to be updated. Now I will have to get the instruction whether the accused person appeared before that.
Have you appeared?
Yes. In 47, I have appeared on 14/11. In 48, I have appeared on 24.
What is the offense?
Well, FIR is at page 9, my lord.
Page 9, sir.
The allegation is that from the account of the bank account of the, my lord, victim informant, my lord, fraudulently, my lord,
Okay, you take the.
Yes.
In both the
my lord, both the cases.
done it. Third, Mr. You can't stop it. Also heard the Board of petition submit that though the case diary is available, name is not updated and seek leave of the court produce and update it.
I will also get a, my lord, status report of the, my lord, case, because otherwise, my lord, matter relates to, my lord, transferring of the response to
Updated case diary
Yes.
as well as a status for investigation.
yes,
Status report of
because otherwise offense is serious.
copy. declare let this matter
On my lord, 18th of January.
18 that
I may be allowed to return back the case diary.
the interim order shall the case diary may be returned back to be called again after update. It was adopted.
But it is not a bit. I have been checked.
Heard means
Yes.
as that also heard it got a praise for the let this matter be
On 11/1.
given for interim order shall
But annexed
Forest Department is there.
Forest, my lord, we have, there are two cases. One is PS case and one is forest case. So, my lord, they are asking for passing of a charge sheet,
FIR and charge.
FIR and charge sheet.
Now what it is,
My lord, immediately, my lord, proceedings below the court below may state, because the petitioners are from Arunachal, my lord. They were most unduly intercepted, my lord, were coming from, my lord, Arunachal. In Harmoti, they were, and the false case has been lost against them. My lord, prima facie, there are no ingredients of the offence alleged of proceedings kindly come to annexure A, my lord. Page 17, my lord.
My lord,
And
he
section
has to
56.
state under, this is charge sheeted case, my lord. We have to apprise, my lord, the court under, what is the stage of this case?
My lord,
I
this
tell-
is the stage of appearance, my lord. My lord, let's say the proceedings, my lord, and fix another date.
no, for staying of what is the count?
My lord, there are no ingredients, my lord. Lordship may kindly see page 17, my lord. If the affair has been lost by the officer in the,
There is no ingredient in the FIR.
Yes.
But in the charge sheet during
it's the
investigation,
same stereotype sentence, my lord. Lordship may kindly see page 19, the section that is in, under section 56, Wildlife Act. We do section 279, 275 means, my lord, rash and negligent driving, my lord. And 337 is causing simple hurt. There is no injury, my lord. And section 27(2), my lord. My lord, that was a simple gun, my lord, the .22 rifle gun, my lord, is soft electricity, my lord, with licensed gun, my lord. And Lordship may kindly see what the section 56 says, my lord. Lordship may kindly see section 56 of the Wildlife Act. For a moment, my lord.
no, Mr. Gogoi,
My lord, granting
You are ready.
My lord, granting interim,
Other than any offense.
granting interim would amount to granting him the final relief if on the face of the submission, no, if, no, my lord, if on the face of the submission that there are no ingredients in the FIR, it will lead to the final relief, my lord.
My lord, I am not.
no, therefore I'm,
Not
are you ready to
today, I'm not,
take your sub?
not, I have to go through it, my lord.
He has,
Yes,
My lord, the last time also they were absent, my lord, and matter could not be taken up. And I have to catch for him the entire day. And he immediately says that I am not concerned because it is a police station. Forest means that there is forbidden weapon. My lord, may kindly grant me stay.
no, for that I have to
My
be
lord,
convinced.
56 does not say about any offense of the violence. Kindly stick. 56 is main offense, my lord.
Okay, there is no wildlife offense. Then
It is
under
offense-
section,
Huh?
under section 279,
217, my lord, may kindly see, I have alleged, Lordship may kindly see, the injury report, my lord. Lordship will find postmortem report 54. Page 64, my lord.
no, and 27 clause 2 of the Arms Act.
Yes, my lord. 27 to clause 2, 4, my lord. Lordship may kindly see the arms act, my lord.
No, what is the
My lord, the
allegation?
allegation is that 57(2), my lord, that is regard to prohibited arms. And my case is not under prohibited arms. Lordship may kindly go through the Arms Rules 1962, my lord. Schedule 3. Lordship, I have got a copy, my lord. Schedule 3 says, Schedule 1, Rule 3 says prohibited arms as defined in section 2(1).
No, no.
Yes. First of all, my lord, I have not done any hunting by way of gun, my lord. That is postmortem is clear. Had it been I have shooted the bird, my lord, after such a false allegation, there have been some bullet injury, my lord. First, you may kindly see page 64, my lord.
No, let Mr. Gogoi come. back.
And there is a wildlife officer. I'll ask for the
Not
We
offense.
were fixing it on 26. Or first of, first week,
22nd.
22nd will
23.
be.
Huh?
At what stage the case
Like it's fixed for appearance.
when?
Last week was 620 December, maybe in the first part of the
So then first, let it be first week.
date to
Third, it's the 8, but. Case there,
days. No, I am only paying for stay of proceedings.
I'm not paid. Whether
No, my lord, it was
Third,
it's
Mr.
in the last
DK,
order that
DK Bharti,
they will be considered as an
done it counsel for the. Also heard Mr. D. Gogoi. Done it special public for it. but Done it counsel for the forest department. Praised for some time to prepare against the, prepare to reply against the submissions made by the council for the prayer is allowed. Let this matter be considered again. 10th of that, on which date the prayer for derivative. Not that date,
Hold it.
item number,
Just voted it application. So the name is there, but because
yeah, it is there. They have appeared,
Appeared.
heard Mr.
the account here, but
Mr. D. Dekar, and the council for also heard Mr. P. Bota, the petitioner for the Senate council for the petitioner has submitted there are two petitioners that by order dated 15/11/2023, the petitioners were granted interim prepared by this court, and in pursuant to the directions of the court, they have appeared before the investigating officer. Have cooperated with the. On the other hand, the petition prosecutor has produced the case diary of Bakipur PS case number 309 and has submitted that the petitioners have appeared before the and their statement, the section 161 here have considering fact that petitioners have cooperated and have complied with the direction. The interim prepared not the above petitioner by order 15/11/2025 court hereby with condition number within bracket small b attached to the state order with of the state.
51, section 6 of the POSCO Act.
But the report service report heard means P. Bora, the counsel for the petition also heard that P. Thakur done an additional paper submit that the case diary is available, however, from the office note dated. You have to ensure the service of.
Yes.
Office note dated 5/12/2020 states that the service report on the service of notice on component number 2 has not yet received. It also appears that the petitioner had taken steps for the notice on component number 2 by registered secretary and not as per the mode prescribed by this court. By division bench of this court in Deepak Nayak state of Assam. Petitioner is directed to take fresh steps for service of this as per the mode prescribed by the division bench of this court in Deepak Nayak versus state of Assam. Let this case be listed again on 18/21 or 20/22/1.
Map with item 50, maybe this photo is 30 days. Granted, they start pay.
First it submitted. 50.
The item
Yes, but
heard Mr. S. Ahmed opted for submit that it in it has become infructuous as matter has already charged it. Consider submitted opted for it and it means not
I don't want,
yes, but
I don't keep with him. I am on interim shortship and accordingly after obtaining it, they prisoner went to the Thana and he recorded this statement.
Yes, my statement recorded.
how much left out? 53. Same.
City received now my lord, only two city 53 and 55.
55 already 3 days are left. On
Earlier
3 days,
earlier rejected.
rejected, 3 days left over. Date maybe
Date will be
22
given by
got the
court master.
or
Item number
53 lakh.
53. The petitioner appeared before the other. It has cooperated in the case.
Yes.
what to it. What to it.
Okay,
Very
court
important.
master will,
Item number 65, can it be on 22 not?
he has to see the upper court. If it can be,
Before vacation.
your
Hearing 65.
hearing matter, let it,
Just 15 minutes.
we have seen the date. Every
See,
day
if it
we are getting lot of bad hearing matter.
Just
we
matter
could-
maybe if it is possible.
Okay. Because all dates are set of person. Okay, you take a date as per your topic.
Hello.
Item number 71, Lord. 438 application. Petitioner number 1 has been arrested. Name may be above and other two petitioner interim may be.
Item number 59. I'll make it, there is no in. Only may be different.
I am not is very urgent. Get it fixed tomorrow or day after considering file will pass. Now all leftover matter, court master will give date, take date as per it. Wherever there is injury, it can.
ফ্ৰাইডে দিয়ক এদিন মানে কি হলে হ'ল ইণ্টিম নাই সেইকাৰণে উপায় নাই আৰু last day।